questions this morning, and then this afternoon we'll have a short general inquiry wrap-up session to agree arrangements for the accompanied site inspection and for closing submissions. And then later in the afternoon, we'll return to the topic of radar mitigation. Can I first check who's participating today, please, and just that their technology is working? Who's appearing for the applicants?
Good morning, sir. My name's Colin Innes, and I'm from the law firm of Shepler Wedderburn. I'm appearing on behalf of the applicant this morning, and I'm accompanied by David Bell, who you heard from at the Energy Policy and Planning Policy session, and also accompanied by Ewan MacLeod of my office, who will potentially come in on conditions where he's been leading certain of the matters and evidence. So that's the team that we anticipate presenting this morning. Thank you, sir.
Thank you. And for South Ayrshire Council, Mr. Campbell.
Campbell and the Queen's Council, and instructed by South Ayrshire Council, as you know. Supervisory panel. So
you're very quiet, Mr. Campbell. I don't know if you could move closer to the microphone or.
Good morning. Is that any better?
Not really. I can hear you, but you're just quite quiet.
Is that any better, sir?
Perhaps a little. But go ahead anyway, and we'll move on, and you can fiddle with your settings while we're talking to other people.
John Campbell. I'm a Queen's Counsel. I'm representing South Ayrshire Council.
Right. I think we can't really hear you very well, Mr. Campbell, but I think you said you were accompanied by Mr. Edgar.
That's correct. Correct.
Yes, I don't know if it's an issue with your microphone or your settings, but we've obviously heard you very well the other days.
Persevere, sir, see if we can make it better. Put some headphones on.
Thank you. Moving on to Nature Scott.
Morning, it's Jennifer Jack, partner in MacLeod Solicitors, appearing for Nature Scott, along with Lindsay Kinnis from Nature Scott.
Thank you. And Glasgow Prestwick Airport.
Good morning, sir. It's Ewan Brown, and I'm counsel appointed by the airport for the inquiry.
Thank you, Mr. Brown. Moving on to other parties, I can see Mr. Shaw. Mr. Shaw, are you here representing just yourself, or also Ms. Kendall and Ms. Spinks?
I think probably just myself. I can see Ms. Kendall online, and
oh, yes.
Yeah, probably say just me.
Good. And Mr. Grosvenor.
Yes, I'm representing Mrs. Crosswaite, and also in conjunction with the other witnesses we brought to the inquiry, specifically on wind turbine noise.
Excuse me, could I just interrupt and say, if possible, I'd like Mr. Shaw to represent me today as well. I won't be able to attend the whole meeting. I've got other meetings scheduled throughout today.
Very well. I've got notes. I think you included some notes about conditions in your recognition, didn't you? So I've got a note of that.
Thank you.
So thank you. Yes, Ms. Spence, Mrs. Spence. Can we just check that we can hear you? I think you're on mute.
Yeah, suddenly I wasn't, and then suddenly I was. Yes, I'll be taking part.
Right. Thank you. Is there anybody else? Ms. Crossthwaite, are you here observing, or are you taking part today?
I'm here just to observe Mr. Grosvenor represent me.
Thank you. You were breaking up a bit there, but I think you were saying that Mr. Grosvenor would represent you. But you can join in if you wish later on. Thank you for that. Is there anyone else here who's expecting to actively take part today? Thank you. So good. As usual, we've got quite a lot of people taking part today, so that might cause us some problems with broadband width and so on. So if I can ask people, as usual, to mute themselves when not speaking. Only have one speaker operating in a room at one time to avoid feedback. And for those of you who aren't participating, to switch your videos off. I won't repeat the announcements I made at the start of the inquiry regarding COVID and webcasting and so on, but they are all available to view on the webcast the 24th of May. So before we start our conditions session, are there any more general procedural points anyone wishes to make? Good, then we'll move on.
Yes, sir. I've just got a couple of comments to make. It was just to say, sir, that the applicants have carried on engaging with various consultees and parties, even after the publication of the draft conditions and the responses. And insofar as those are ongoing discussions, we will address any matters that arise from those discussions and the discussion of the individual conditions. What we thought was rather unhelpful is to start trying to put more documentation in effectively late in the day, when it would have just added to confusion as to which versions people were working from. So as I say, we've kept to the versions that were submitted, but we have had ongoing dialogue with parties to seek to try and narrow matters related conditions. And insofar as we've made progress, we will outline those when we come to the relevant conditions that are being discussed. But as I say, we've not lodged further documentation because we thought it being late in the day, it would just cause confusion as to which documents we were referencing and which conditions. So, but as I say, I thought we'd just highlight the fact that there has been continued progress, and we are trying to address concerns that have been expressed in relation to the draft conditions.
Yes, that sounds sensible. And presumably, if you've agreed amended wordings, they can submit it to me in writing at some point. Thank you. Well, let's move on then to the conditions session. So this is going to be a session, so hopefully we can keep it relatively informal. Firstly, I do need to make clear that because we're having this discussion about conditions, that does not prejudge my recommendation on the development itself or Scottish Minister's decision. But in my reports, I do need to set out a list of conditions for Scottish Ministers to impose in the event that they are minded to approve the application, regardless of what recommendation might be. I will be guided in part by Planning Circular 4/1998, which states that planning conditions should only be imposed where they are necessary, relevant to planning, relevant to the development, enforceable, precise, and reasonable in all other respects. So we've had the draft list of conditions produced jointly by the applicant and the council, and that's contained in folder 15 of the memory stick, so I hope everyone's seen that. And we also have further comments on those conditions received from Nature Scott and from Glasgow Prestwick Airport, which are also contained in that folder 15. And I've also noted the more recent submissions from Mr. Shaw, and also the suggested conditions set out in Ms. Kendall's recognition on noise. And we also have an email from Ms. Crossthwaite this morning regarding noise conditions, which I think at least partially incorporates Ms. Kendall's suggestions.
Yeah.
As we go through the hearing, I'll generally go to the applicants and the council for their comments. And any other parties who I have already noted have an interest in that particular condition. And then I'll just ask generally if anyone else has a comment to make. So please switch your video on and raise your hand if you wish to speak. And if I don't spot you and we appear to be moving on to the next condition, then please speak up. I'll also seek views at the end as to whether there should be any additional conditions relating to topics that we haven't already covered. Before we get into conditions themselves, I did firstly want to confirm whether parties thought that all the necessary matters could be covered by conditions, or whether a planning obligation or some other form of legal agreement should be used instead to secure any matter. And I suppose I'm thinking in particular of in other wind farm cases, sometimes it's been suggested that the restoration bond should be covered by a legal agreement, and also the possibility of the radar mitigation scheme being covered in that way. If I could come to the applicant first, for just on that point about the whether there's any need for a legal agreement in this case.
So yes, our position is that there's no requirement for a planning obligation. The matters you raised by way of example were fairly standard by way of dealing with by way of condition. For example, all the consents in Highland, for example, Section 36 consents require a bond by way of condition, not a planning obligation. And that's the position that the ECU and Scottish ministers take on those decisions as well. There's a number of them before the inquiry.
Thank you. And Mr. Campbell, is that also the council's position?
Yes, it is. I hope my audio has improved a wee bit, has it?
Much better. Thank you.
Thank you. Yes, that's the same. Our position is the same as far as I am instructed.
Yes, I mean, certainly it's my preference to use conditions if at all possible. So we'll assume that we'll go down that route. Good. Then if we can move on to condition 1 there, which is relating to the duration of the consent. And there's dispute between the applicant and the council here. Perhaps, I don't know if this is again for you, Mr. Bell, if you could briefly set out your argument for why this should be an in perpetuity consent.
Thank you, sir. I think parties have seen the notes on the schedule of conditions that came round, and it's quite clear from the onshore wind policy statement, that's CD 4.12, and indeed SPP, which is CD 4.1, that consents being granted for wind energy development should be for development that is suitable in perpetuity. That was introduced back in 2014 as national planning policy. And the recognition, I think, is twofold. One is that the technology is maintained, and as in line with any other type of development, if development is maintained, there's no reason why it should necessarily be dismantled. We don't do that with housing projects or factories and other forms of development. But also, as we explored in the hearing session in terms of net zero and the climate emergency, the policy imperative on that topic means that targets need to be sustained into the long term. It's not simply a matter of we reach 2030 or 2045 and that is the job done. Clearly, the electricity generation from renewable sources is a long-term benefit. The other factor that's important is that Circular 498 makes it very clear, and it's been a long-standing planning principle, that one should not rely on the time-limited nature of a consent to protect community, and that's never been a position of the applicant, and the EIA assessment has been undertaken on the basis of the development being in perpetuity. So against that background, and in particular the policy position, the applicant's stance is that it's appropriate to grant the consent in perpetuity and not to accept the council's proposition on that matter. Thank you.
Do you know if ministers have granted other consents now with in perpetuity. Well,
I'm not aware of that, sorry. No.
Mr. Campbell for the council.
Yeah, the genesis of the 25-year limit goes back really to the 1990s, when it was considered that the equipment for which consent was being sought was necessarily of a limited life. That is still the position. The council's preference is for the 25-year limit in line with other surrounding developments, Clauchrie and Clauchrie, and indeed its submissions to the Clauchrie extension. I would defer to Mr. Edgar on this, but we would, in the end, just leave the matter to you, I think. So I don't know, Mr. Edgar, if you have any.
Mr. Edgar, do you have anything to add?
Nothing really to add. So yeah, the sort of temporary consent relates to this sort of above ground structures, if you like, rather than a wind farm per se. It's the nature of these nature of turbines that they will, over a long period of time, they will wear out. They will start to eventually deteriorate, unlike a permanent building. And it's our position that the 25 years is a reasonable length of time to then hold a full review of perhaps the physical conditions of that wind farm. Hence, we would put our preference in for 25 years time limit.
So if an individual turbine wore out after a period of 23 years or whatever, and the developer replaced it like for like with an identical turbine, then that, in the normal run of things, that wouldn't require planning permission, would it?
No, if we have a condition that allows for that, but it could be in 25 years from now, we don't know what the condition of that wind farm overall will be. And I think it's still appropriate to have a review at 25 years. There may be a lot of redundant turbines by that time.
Thank you. Mr. Bell, do you want to come back on any of that?
Yes, sir. I mean, the points raised about potentially redundant turbines or issues arising from deterioration of conditions, there are planning conditions proposed that we'll come on to that cater for those eventualities. So there are safeguards in place to ensure that amenity is preserved over the longer term and that the benefits will continue to flow. Plus, the standard approach for wind farm operators is to maintain the plant and equipment in good condition. So that the position of the council is not accepted in that regard.
Thank you. Can we move on? Does anybody else have anything further on condition one? Yes, Mrs. Spence.
I am concerned that after 25 years, or even in a shorter period, that technology will have moved on, and it seems to be moving already away from onshore wind turbines, and that 25 years is a long time anyway. I'm also concerned that if old turbines that are no longer used are left in the position that they've been put in and not removed, they constitute quite a considerable risk from fire. I don't think that there is a proper efficient way of putting out a fire when they go on fire. And I think that that would be a very considerable risk if it wasn't accounted for. And also, who wants a landscape in whenever with a load of clanking, useless turbines hanging around? It's not going to improve anything. It's going to detract from the landscape.
I think there are other conditions that we'll come on to about removing turbines that have if they become redundant and are no longer being used, then there's a condition about removing them. But I do take the point about at some point in the future, technology may have moved on. You know, we may have nuclear fusion or whatever it may be, and perhaps turbines won't be required anymore.
Okay.
We'll move on from there, I think. Go on to condition 2. No dispute between the council and the developer on this one, which is a standard condition about development being commenced within 5 years. Any other comment from anybody on 2? Then we'll go on to condition 3, non-assignation. So this is about the name. I take it this is about the name of the developer and the developer potentially being a different body from SPR, and this condition would prevent that without the planning authorities being notified.
So the ministers.
Or ministers, sorry.
Ministers. The purpose of this condition, as I understand it, is to prevent assignation, no doubt for a consideration among developers or between developers without the Scottish ministers being able to keep an eye on what's happening. You'll remember that Section 36, of course, is designed to control, was originally designed to control access to the grid, and Scottish ministers, I think, retain at least a vestige of that authority. So we don't oppose this. We think it's a reasonable provision to have. I just have one comment on the drafting, as you'll see in the right-hand margin.
Yes, I've seen that. I take it this is a typical condition that is imposed in most Section 36 cases.
Yeah, certainly in my experience it is, yes.
Okay, good. Then if no further comments on condition 3, we'll move on to condition 4. So, Mr. Campbell, the council's proposing a slight modification here. Relating to private water supplies.
Yes, I've got it, sir. I'm just absorbing it. No pun intended.
Why you asked was my thinking was whether that particular element, we've got private water supply conditions later on, whether this content can be included there.
So our position on that is that the Section 36 conditions in particular, and this specific one, is for serious incident reporting. There are conditions later that will deal with the actions around private water supplies. I think also it needs to be remembered that in the circular, under the need for a condition, it does set out under the test of need that we need to avoid imposing conditions through anxiety to guard against every possible contingency, and even that adding a condition because it will do no harm is no justification. So given that, and we have provisions elsewhere that provide for this particular circumstance, there's no need for this to go into the actual Section 36 conditions of the consent.
Mr. Campbell, you
what I would say is
no, sir, we're not happy with that.
I would add,
sorry, I'm getting some feedback. Can you hear me all right?
Can you hear me all right?
I'll just hear from Mr. Campbell, and then we'll come back to you, Mr. Bell.
Sorry, David, if you haven't finished, please go ahead.
It was just to say, in saying that, I'm not in any way seeking to downplay the seriousness of any issue around private water supply. Of course, for any owner that would be, but there are conditions that hopefully can provide an assurance elsewhere in the deemed planning permission that cover for those eventualities.
So I think this is really a matter of drafting first and foremost. The title of the condition is serious incident reporting. The title is not part of the condition, and the word serious doesn't appear in condition 4. So as it stands, condition 4 is about any breach of health and safety or environmental obligations, whatever they are, and they're not defined. Miss Lobbin's advice to the inquiry, to me and to the inquiry, was that if there was an incident, obviously her concern is with private water supplies, but other incidents can be figured, then the council should also be notified so that it can liaise with the Scottish ministers and perhaps take action on the ground more quickly than Scottish ministers are able to. It is, I think, axiomatic that the Scottish ministers, although they are the nominal consenting authority for this type of application, they're not exactly nimble and flexible when it comes to acting quickly in the event of an emergency, whereas the council is capable of being both nimble and flexible if, for example, there was a flood or a private water supply incident. So we would like to be included in this condition, not because it does no harm, and I accept Mr. Bell's submissions on that aspect, not because it does no harm, but because it's necessary.
So where you say that the council should be informed in relation to private water supplies, then potentially that could apply to other aspects as well.
It could potentially, yes. I'd like to hear. Sorry, if I may ask through you, what Mr. Bell thinks is meant by serious incident reporting. Clearly, everybody will have a view about what is serious, and the council's view will be different from Mrs. Spencer's view, be different from the applicant's view. If you spill 5 gallons of diesel, it's serious locally, but it's not serious over the piece. If you spill 1,000 gallons of diesel, then it's a different ballgame altogether. So there has to be some better definition in this condition, in my respectful view.
Yes, I mean, I also thought this was rather a vague condition, but then I noted it is the standard wording. So on that basis, I was prepared to accept it. But Mr. Bell, do you have any further comments?
Yeah, I think the starting point is it is standard wording. ECU accepts it, and the ministers are content with this condition. It's over numerous consents. I think the circumstances of any incident, it will be a matter of fact and degree, and a judgment will be required. But we do have a suite of conditions that we're coming on to that show how there is a split between the Section 36 matters that the ministers want to be concerned with and the obligations that the planning authority will have with all their enforcement and other powers on the ground. They're very nimble, as Mr. Campbell puts it. So there needs to be a judgment made about what matters are for the ministers and their attention and what are other important matters that, of course, the planning authority has the capability to deal with in its wide service provision.
Well, with respect, David, you've not answered the question because we still don't know what is to be regarded as serious, and the word serious doesn't appear in condition 4. So unless you can provide some better specification, I know it's a standard condition, but with respect to the Energy Consents Unit, it's a bad standard condition because it lacks precision. It fails one of the tests of the condition. What?
I think the various schemes that we're coming onto and plans that need to be prepared will set out circumstances in which actions need to be taken if there is a cause or an effect arising. And that is what these schemes can deal with. And we're coming on to those.
Yes, I mean, I think it'd be very difficult to include a comprehensive list of all the potential.
Yeah, I agree.
I agree. I think I tend to agree. Also, perhaps with both of you, that the problem is more with the condition itself. But if it's a standard condition, then.
But just because it's a standard condition promulgated by the consenting authority doesn't mean that you should approve it if you're not satisfied that it's sufficiently precise. Because for the moment, sir, you're the planning authority, and you need to impose on the development something which will work. So I don't want to repeat my submissions.
Yeah.
I think you know
So,
the positions.
the other point on that, in terms of the Section 36 conditions, are that there is a section in the Electricity Act that provides that ministers can attach any condition that they consider is necessary. So it's separate from the Circular 498 provisions, but there is a section of the Act that provides for that provision.
Still a bad condition.
Thank you, Mrs. Spence.
I think that I've read through the conditions that are being talked about that are coming along later, and I haven't seen anything that would account for the private water person who has to rely on that water to be compensated and for their supply to be properly replaced or whatever needs to be done without it causing them considerable expense. And given that the paper that the email that I alerted you to yesterday, I feel that the applicant is not very prompt or willing to reinstate any damage that they cause anyway. And I can imagine how difficult it would be for any person who is reliant on a private water supply, first of all, to get them to get off their backsides and do something about it, and secondly, to make sure that the person who is affected does not have to spend a lot of money suing them in order to get some action. I mean, there must be some provision that people will have their supply reinstated or have proper remuneration, restitution of their situation. And as Mr. Campbell says, this standard conditions are obviously totally inadequate, and I think something proper to protect people should be agreed. I know.
Yes,
that
we can add further conditions beyond the standard conditions, or we can vary the standard conditions if we or if ministers see fit. I think I'll move on, because I think we will be covering water supplies later. Mr. Shaw, I don't want to get into an in-depth discussion about private water supplies now, because I don't think that's the point.
I appreciate that. So I wasn't even going to mention private water supplies. I mean, this condition says, in the event of any breach of health and safety or environmental obligations, under such circumstances, then the developer is obliged to report to the Scottish ministers. A breach of that nature would clearly be, I would have said, be required to be reported to the council under their health and safety obligations. I think you might perhaps just consider whether such a breach should be reported to the affected householders, because that would be really nice.
Fair point.
Yeah, made a note of that. Thank you, Mr. Shaw. Can we move on to condition 5 then, which is about aviation lighting? And again, there's a difference between the council and an alternative wording has been put forward by the council for this condition. Perhaps if I could start with Mr. Bell or Mr. Innes. Do you have any difficulty with the alternative put forward by the council, Mr. Innes?
Yes, I do. The position that we have adopted is that we're committed to delivering the use of an aircraft detection lighting system, and that is effectively not what is provided there, because it's more a scheme which demonstrates minimisation of visual impact of a proposed lighting including. So our position is clear cut about what has to be provided, and it sets out those principles in a clear, precise, and enforceable manner. We have committed to all these measures as part of the process. So we, on balance, do not think the Council's drafting adds anything, and in fact, potentially weakens the proposition relative to what is being offered. The second point is NatureScot also wanted to be part of the consultation process as set out in the underneath the applicant's 1 to 3 bullet points. We have the word Civil Aviation Authority, and we don't see there's any difficulty in adding NatureScot to that matter and adding NatureScot, and equally in relation to the reasons, it's in the interests of aviation safety and to minimise landscape and visual impacts. In addition, Glasgow Prestwick Airport also want to be a consultee. Given the evidence that was heard on the matter, we don't think they justify that status in relation to this condition.
I'll go to the council first, and I'll come to the airport and NatureScot after that. Mr. Campbell.
Thank you. The draft which the council has offered obviously picks up part of the case that it's making before this inquiry in respect to minimisation. If one listened carefully to the evidence of the applicant's experts, it was clear that that too was part of their ambition for whatever system may be developed or may evolve and may be employed, subject to the approval of the Scottish ministers. The local authority is not asking for the role of a body that approves this system, because it recognises that it doesn't have the competence to approve matters in that way. But the draft, which we consider to be better than the applicant's draft, simply incorporates the case that we have made before or part of the case which we've made before the inquiry. So we would maintain that it's a better draft and it should be preferred. Of course, we don't speak for the airport or NatureScot.
No, I'll come on to them now. Ms. Jack.
NatureScot is pleased to see that the applicant is agreeable to include consultee. Beyond that, whichever wording you prefer, sir, between the wording proposed by council and the wording proposed by the applicant, we would leave that matter to you, but we'd ask that regardless of which set of wording is chosen, that NatureScot would be included as a consultee.
Thank you, Mr. Brown.
Thank you, sir. As Mr. Ennis has indicated, the airport has suggested in response to further communication on this condition that the airport should be a consultee. I don't accept, sir, that the evidence led by the airport, or rather, I would submit that the evidence led by the airport demonstrated that the airport has an interest in the airspace above the development site. It's obviously providing services in that airspace. There was also evidence led that by the applicant that, of course, if the ADLS system is introduced, that would be a new system for the United Kingdom. And the airport articulated its concerns about what that might mean. There is no intention here, sir, on the part of the airport to try to frustrate the applicant in introducing an ADLS system, but there are practical issues which arise, sir. So, for example, if an aircraft is receiving air traffic services from the airport and they identify they have a failure in their transmitting device which will not activate the lights, how is that to be resolved? What if the airport receives a report from an aircraft that the lighting did not come on and its transmitter was working? These are the practical issues which may arise in connection with the operation of the ADLS system. And the reason for the airport suggesting it should be a consultee is to provide a mechanism for the airport to provide its concerns, its practical concerns to the applicant with a view to identifying how the local issues which may arise can be resolved for the benefit of all concerned. So it's a well-intended intention. It's not intended to frustrate the introduction of ADLS, but it's simply to deal with the practical issues which may arise.
Yes, it wouldn't seem to involve too much additional difficulty for the applicants to include the airport to me, but Mr. Innes, do you have any further comments before we move on?
Yes, sir. I mean, the correct body for the formal consultation is the Civil Aviation Authority. They may well engage with other aviation interests in the area, but they are the right party in which to discharge and give advice to the Scottish ministers relative to the discharge of the condition. And that's what we're really talking about here. It's not who might have an interest, but who will assist in terms of their particular role, the ministers in their determination. And it's clear that it's the Civil Aviation Authority that are the proper and correct party to whom the ministers should get advice. And that's really the position, and it's the applicant's position, that in respect of this matter, it's clear that what's happening here is the Scottish ministers are taking advice from the appropriate regulatory body relating to the specific matter. And that's why they are the named consultee in relation to the discharge of condition. Other people may have interests and there may be practical measures around it, but that's a separate issue. In my submission, one should not add somebody to the consultee list just for convenience. It's who's the right party to give advice to the particular decision maker in relation to these matters. And in my submission, it's very clear that it's the Civil Aviation Authority that is the correct party to give that advice to the ministers.
Thank you very much. Any further comments on this condition? Then we'll come on to condition 6, which is aviation radar. We haven't completed our discussion of aviation radar yet at the inquiry. We've got a holding wording in here, I think, that neither party agrees with. Mr. McLeod, your client's position is that no condition is required at all, but really that's the whole focus of our discussion at the inquiry session. So I'm not sure if it's fruitful for us to discuss that much further here, but do you have any quick comment to make?
I would agree with that, sir. I mean, I think my submission is that the evidence that you've heard to date demonstrates that there's no operational impact that would justify imposing a condition. If you consider there is a need for mitigation, then the applicant accepts that there may be specific limited works at the outset that should be covered by a condition. But I would suggest that we park that issue until we hear the evidence later this afternoon and over the next day or so. And my suggestion was going to be that, having heard the evidence, parties then put their final position on what an appropriate condition would look like into their closing submissions, so that you have a final position from both parties on that issue.
Yes, I mean, you'll recall that I've raised this matter in questions to witnesses as well about the possibility for a more specific condition here. Mr. Brown, are you happy to park this issue for now and then come back to it in the full session and in closing submissions?
Yes, sir. I think that's probably the sensible way to approach the issue of the condition.
Good, then we'll move on to the conditions attached to the deemed planning permission then, and condition 7. Again, not agreed by the parties. Mr. Innes, do you want to give us your views on this one, please?
I'll deal with that.
Sorry, Mr. Bell.
That's fine. We've set down that the standard approach is that there will be an annex attached to the Section 36 consent, which will set out a description of the development. So that would negate the need for the condition that is shown there. Just to give you an example, CD 6.17 is the Paul's Hill 2 Section 36 consent, and you will see in that in the letter from the ministers, they grant consent under Section 36, which they say more particularly described at Annex 1. That's on the first page of the consent. And Annex 1 is a description of the development, which is about a page long. And there is not, therefore, a condition on the deemed planning permission duplicating that provision. So that would be the approach that we would commend. And if it would help, we could draft up a similar annex for this development and submit that.
I think that would help, yes, if that's a possibility. Mr. Campbell, I think the council is of the same view. I think you're on mute, Mr. Campbell.
Yes, sir, we find ourselves in agreement with Mr. Bell. Thank you. Can you hear me all right?
Yes, that's fine. Just taking a note. Any other comments on condition 7?
Not from me, sir. Thank you.
Then we'll come on to condition 8, which is agreed between the council and the applicant. Further details of the designs of the design of the turbines. Any further comment from anybody on this? Then we'll come on to condition 9. Again, that's agreed by the parties, requiring the development to be constructed and operated in accordance with the approved details. Any further comment from anybody? And condition 10, turbine blades to rotate in the same direction. No comment from anybody.
I did wonder, sir, whether it's probably not possible to frame a condition, but given the proliferation of wind turbines in this area, there's anything to be said for requiring consistent direction of rotation among the different wind farms. I dare say there's a technical reason for them going clockwise rather than anti-clockwise, but this is just a passing thought, really, to avoid visual clutter and visual confusion. Perhaps, given where this wind farm is, I just make that observation. I'm not going to insist on any change in the drafting. The applicants might want to take note of it, though.
Yes, Mr. Bell, I don't know if you're qualified to comment on that matter today.
Well, from a planning perspective, there's no necessity for that provision. It's an interesting one Mr. Campbell raised. I don't dismiss it, but there's no necessity here for that, I would suggest.
Thank you. And then condition 11, agreement between the parties, the display of logo signs or advertisements. No comments about that one. Good. Come on to condition 12 then. Agreement between the parties again. Further details to be approved by the planning authority. No further comments.
I think a householder might say that if there's to be external lighting, and this can't really be a condition because it's not possible to frame it, but a householder might say if there's to be any external lighting of the substation building or any compounds, that care should be taken to direct that lighting away from any residents.
And that can all be captured by this condition, can't it? If
well, it can.
Those conditions fall to be approved.
The condition could be twice the length with all the different residences set out. I'm really just asking the applicant to note that it would be desirable if external lighting could be configured in such a way that it doesn't interfere with the amenity of any residence.
Mrs. Spence.
I have noted that particularly Kilgallick Wind Farm does a lot of overnight maintenance with a lot of lighting, and I would suggest that that is not allowed, and that a condition could be put in that overnight maintenance would not be done if it required lighting to any great extent, because this is a dark skies area, and so is the area covered by the Clauchrie extension. And I don't think in any case that any wind farm should be lit up at night for the convenience of the applicants.
I can't immediately recall if we come back to lighting at a later condition. It may be that we pick up on that later, but I've certainly made a note of that comment here as well. Mr. Shaw.
Thank you, sir. Yes, I did mention this in the list of possible conditions that I submitted. In one of the earlier sessions, Mr. Welsh did confirm that the applicant doesn't do maintenance at night, and it does rather leave an open question as to what is going on Mark Hill and Kilgallick that requires flood lighting at 3 o'clock on a winter's morning. So I would be very keen to see a condition, and I think the rest of the householders along here would be very keen to see a condition that simply reinforces the situation which Mr. Welsh said existed, that to the effect that planned maintenance is not done during the hours of darkness, and only emergency maintenance or emergency works are undertaken for exactly the same reasons as Ms. Spence commented, that this is a dark sky park and we just don't really want to see this kind of park.
Mr. Bell, I don't know if you've got any comment there, and as I say, I'm not sure if we're going to come back to this later.
So I'm not aware of that lighting incident, or indeed if it was on a wind farm or where it was. There's no evidence of that. Clearly, if there are health and safety or emergency issues, there needs to be lighting, and that is covered under other statutory provisions anyway in terms of health and safety. But the applicant's approach would be to put in the minimum lighting required, and the condition requires details of the lighting to be provided. So I think there's adequate provision for the planning authority to control that.
Yes, I mean, I think this condition isn't about emergency maintenance lighting, it's about lighting that is part of the permanent development, as I understand it. Ms. Crosthwaite.
Yes, I would just like to say that Ms. Kendall, who's not has alerted me to the fact that like the Mark Hill and you obviously said that this will be later, but I do live in a lots of the villages have lights, but a downlight rather than lighting up the sky. And it would be quite good to have a condition in here that required buildings to have that kind of lighting, because we are in a dark sky park.
Thank you. I've made note of that. Ms. Crossbait, you break up a little bit when you're speaking, so I think probably the best thing is for you to have your video on when you want to draw my attention, and then once I come to you, if you could then switch your video off to actually speak. But you were coming through enough for me to hear what you said there. So.
Thank you.
Mrs. Spence again, yes.
The comment that was made that it was only one occasion, which apparently the applicant seems to be unaware of, is not correct. The lighting on these wind farms occurs quite frequently, and I can't precisely say how, when, but certainly probably a dozen times in the year. And that is a lot of extra lighting that should not be allowed. So I think you must put a fairly strong condition in there.
Thank you. Come on now then to condition 13, which is around micrositing, and I think the main differences here are that the applicant is seeking 50 metres micrositing allowance, and the council seeks 30 metres, and that the airport seeks notification of the final position of the turbines. Mr. Bell, do you want to put your case for the 50 metres?
Yes, thank you. I think, firstly, in terms of the airport's position, Mr. Innes will cover that shortly under condition 15 when we get to that. In terms of the microsite siting distance, firstly, the EIA assessment has been undertaken on that basis, and the applicant's position is that the convention is 50. If, for example, we just take a sample of the decisions that are before this inquiry, I'll just give you some of the document references for your notes or to look at. But CD 6.2, Larbrax, which is a town and country planning scale development, condition 4, 50 metres. CD 6.4, Penclow, condition 10, 50 metres. CD 6.5, Kirkhill, town and country planning scale, 50 metres. CD 6.11, Point Lawbray, condition 9B, 50 metres. Now, I could go on and list another 7 and 8 decisions from the document list. They're all at 50 metres. So this is a large-scale project. 50 metres has been assessed. It is a distance the Scottish ministers are comfortable with, and indeed would be appropriate here. And the fundamental objective is to further minimise any environmental effects that do arise, and to deal with unforeseen ground conditions that may be identified. So the position is that 50 metres would be appropriate for those reasons. Thank you.
Thank you. Yes, I think I am more familiar with the 50 metre distance than the 30 metre distance. Mr. Campbell? I think you're on mute again, Mr. Campbell.
I'm sorry, I beg your pardon. Of course, I accept what is in those decisions. The fundamental reason for having the license to microsite turbines is to cope with unanticipated ground conditions. Now, part of the applicant's raison d'etre for this project is that despite there being a large areas of peatland, they have managed to site the turbines in areas where they say there is no peat or minimal peat. If that is right, and I don't accept it for the purpose of this argument, then this condition is going to have to say something about not relocating a turbine into an area where there is deep peat. Otherwise, the logic flies away. That's part of the reason why the 38 meters is suggested, because it gives less opportunity to encroach upon deep peat, which is a valuable asset. We heard from the landscape witness that a great deal of time and trouble had been taken in planning the wind farm so that it did not encroach on areas of deep peat. So one is bound to ask, well, why should micrositing be necessary? Of course, excavation can reveal unanticipated conditions requiring micrositing. But for the reasons I've given in my submission, the latitude given should be small. Now, the other thing to say about micrositing is that it ought to be conditioned so that no movement of the turbine's position is closer to a noise-affected property. You may say, well, 50 meters may not make any difference to noise. I don't know whether it will or not, but it could, and it could also make a difference to the visual impact of a turbine. So any micrositing adjustment in my submission should have regard to the position of noise-sensitive properties and visually sensitive properties, and do its best to avoid any enhancement of the effect which has been assessed. Unless Mr. Edgar has anything to add to that, those are the council's submissions.
No, nothing further to add to that.
Thank you.
Yes, I mean, the condition allows micrositing beyond the 30 meters or the 50 meters if the planning authority agrees to it. Does it not?
That's right.
So there still would be the possibility to do that. It would just be an additional check. So perhaps this isn't a matter of huge concern, but I would be interested in the applicant's views on the suggestion about limiting micrositing, at least of the turbines that are closest to residential properties, closer to those properties. Mr. Bell or Mr.
Yes.
Mr. Bell or Mr. Innes?
Yeah, I'm going to come back on 2 points. And the first is that essentially micrositing works. Effectively, the team are all on site constructing the wind farm. And as they progress, they're trying to take decisions which minimize the environmental effects. One of the key matters is that it's effectively driven to improve the environmental performance and reduce environmental effects. And that's why it has to be approved in advance by the Clerk of Works, whose role it is to oversee and assist driving those decisions. Then we're going back and saying, well, why don't we have an approval mechanism? Well, the reason why we don't have an approval mechanism is that there is simply, in terms of the construction program, there won't be time to sit and debate for weeks on end unless there was a very particular issue that wanted to be resolved. And I think the 2 points there is, the first is the environmental performance of the project is enhanced and improved by having micrositing available, and for the environmental Clerk of Works being able to approve those. So that's the first point. The second point, which I note, is that effectively what is suggested is the micrositing should not take place in circumstances where it drives the closest turbines nearer to the residential receptor. I don't see a problem with that one. What can get caught is it's got to be quite carefully worded, because obviously if you word it generically, all turbine movements one way or another will move it closer to a residential receptor, potentially, just depending on where they're located. So it has to be quite specific about how that caveat is put into the condition to ensure that it captures what we're trying to capture, which is trying to not move closer to the closest residential receptors and not all residential receptors, because that's actually something which you can't meet, because by moving it further west, you'll be closer to a further receptor to the west. It's the closer ones that I understand that Mr. Campbell's trying to capture, and I'm pretty sure we could put some wording in to ensure that protection is put in place.
Yeah, so potentially we could list Berta, White Clauchrie, Shallock and Mark Farm as being the affected properties, and say, as a result of micrositing, no turbine. The nearest turbine should not be any nearer than the nearest turbine is, as shown on the on the plan.
Yes, and that's precisely the point. So, because as soon as you start saying generically, any movement within the wind farm might move closer, and it's those closest turbines we're trying to capture, not them all. Because a movement to the west, as I say, will potentially, of any of the turbines, might move it slightly closer to a residential receptor. It's those closer ones. So yes, it's important to have the caveat on it as well.
I think we're in agreement, sir.
I was also going to address.
I think we are in agreement. I was directing my remarks to the closest residential receptors, not to the wind farm generically. So I'm sorry if I didn't make that clear. It appears that the principle that I've been badly trying to articulate has been accepted by the applicant. And so we just look forward to a slight adjustment to the words to capture that issue.
Okay. Thank you, Mr. Grosvenor.
Yes, I just want to confirm that we would accept that with that caveat that the 50 metres isn't any closer to local residents, especially in view that the separation distances are relatively close already. So we would be happy with that condition, worded in that way, specific to local residents.
Thank you. Any other further comments on micrositing?
None other, sir, than simply to note that I think Mr. Innes is coming back to deal with the airport's interest in micrositing under condition 15.
Yes. Yes, we'll remember to come back to that. Thank you. Good, then we'll come on to condition 14. Site plan showing final position of all wind turbines, etc. Agreed by both parties. Any further comments on that one? Then we'll come on to condition 15 then. And Mr. Brown, do you want to come in here?
Thank you, sir.
Go ahead, Mr. Brown.
Yes, sorry. I wasn't sure if Mr. Innes was about to say something first. Yes, sir. Yes, sir. Yeah, all right. Well, I'll let Mr. Innes go first then.
Okay.
What it was is just trying to pick up a number of comments made by Glasgow Prestwick Airport throughout the conditions. And effectively, quite a lot of them were gaining information at certain points of the process. Having considered them in the round, we felt that on balance, that rather than having Glasgow Prestwick Airport and other interests coming into documents like the SEMP, as we'll come on to look at, that it was better to try and address the information that the aviation interests wanted in a more comprehensive condition 15. And effectively, that would address the matters raised by GPA in relation to conditions 13, 19 and 41. And what our intention was to add Glasgow Prestwick Airport to the consultees at the kick-off point in terms of condition 15, and then to add on an additional section to condition 15, which essentially provides more information to the MOD, Glasgow Prestwick, about commencement of development and throughout the construction of the development, 3 monthly progress updates. Upon completion of development, the as-built location of all turbines and met masts, and notification and removal of any turbine or met mast. And effectively through this, what we were trying to capture is those concerns. So the aviation interests had expressed the view through GPA that we're interested in ensuring that they had information during construction, that they got the as-built locations, and that should any turbine be taken away, they would also receive notification. And that was really the purpose of revising condition 15 in that way, was to ensure that we had essentially a comprehensive code of communicating information to the various aviation interests at the various stages of development, prior to construction, during construction, and should anything change during the operation. And that was really what is intended by the change, and essentially beefing up that condition to try and address all those issues in a comprehensive fashion, rather than having effectively the matters scattered throughout the conditions. We felt that was a better way to deal with this particular issue.
So, I mean, you mentioned that there are a few areas where discussions have been ongoing, and perhaps some further changes to these conditions have been drafted. Are these going to emerge in closing submissions, or will there be a further? Are you suggesting a further exchange on conditions in writing?
Well, also, I think it might be helpful for us to produce an updated set of the applicant's conditions. And I note that you're already due to receive, I think, is it a sort of update issue on a matter raised in noise earlier in the week on the 2nd of July. But perhaps if we also submitted on that date an updated applicant's position, to which other parties could obviously address in their closing submissions, and we would respond in our closing submissions, but it would at least provide essentially where we've made progress. You would see the progress and the amended conditions, and there may still be outstanding matters between us, but those are matters which parties can address in relation to conditions in submissions, rather than that's one suggestion. Other parties might say, well, I would quite like to put in my counter conditions in a separate document, etc. There's not a set process here. I'm suggesting a way that meaningfully makes it as easy as possible for the inquiry. And as I say, as the applicant, I'd be happy to try and get our conditions in for the 2nd of July, because we've already got a document going in that day, and it seems to make sense to try and keep things on the same day, rather than having lots of things coming at different days in terms of subsequent timetabling, which we'll be no doubt discussing this afternoon.
Thank you. I'll come back to Mr. Brown first of all, just on the specific suggestion for the revisal of this condition, and then perhaps I'll ask Mr. Campbell and others about the wider issue of the exchange of papers more generally. Mr. Brown.
Yes, thank you, sir. Sir, I appreciate the sentiment here of the applicant that it's better to have one condition which deals with the airport's interests. That's certainly sensible approach to take. I have seen the applicant's suggested new wording for the condition, and I think we are largely there. We're making progress with it. However, the revised wording doesn't quite go far enough, sir, and it doesn't go quite far enough in two minor respects. And I think that really comes around as a result of not having a dialogue at this point with the applicant about what the process of optimisation involves. And I appreciate, sir, that you've yet to hear evidence on that from the radar experts. But the point is that micrositing, even within 50 metres, can have an impact on the optimisation process. So it's important that the airport knows as soon as possible whether adjustments have been made to the final siting of the turbine. And secondly, when the blades start to be fitted to the turbines, that automatically has an effect on the radar, and that means that the airport would wish to start the optimisation process as soon as possible, sir. So the intention here would be to go along with Mr. Innes's suggestion that we try to agree wording by the 2nd of July, and the airport will suggest wording to the applicant, which makes it clear that the airport is to be notified of any microsighting adjustments and confirmation of the dates in which the blades will be fitted and the first rotation will take place, and that's purely to allow the airport to start the optimisation process as soon as possible, sir.
Thank you. And any comment from you on the process for the exchange of papers, and are you happy to see the applicant's suite of revised conditions by the 2nd of July and then make any response by through your closing submissions?
Yes, sir.
Thank you. I'll perhaps come to Mr. Campbell on that broader point about how we deal with further emerging wordings for conditions.
Do you mean in terms of time or timing? We're quite happy to respond to any changes as quickly as we possibly can and to cooperate with you on the dates that you set.
And are you happy for, I mean, it's certainly, I think it probably is useful for me to see revised wordings rather than me having to interpret my notes from this meeting today and devise my own wordings, though I can do that. But it may not be helpful to have lots of different alternative wordings coming in from lots of different places. So yeah. The idea of it seems quite a clean and simple process to get one set from the applicant and then other parties responding in their closing submissions. If you're comfortable.
Yes, always a pleasure to criticise the applicant's drafting, sir. No, we would certainly cooperate with whatever you said. On this particular matter, the council is not going to die in the ditch for any airport-related condition because it's beyond its competence. But we would be happy to see it, and if necessary, but only if necessary, to comment on it. Mr. Innes is smiling. Mr. Innes is smiling, so perhaps he can share the joke. I don't know.
Well, Mr. Innes, we could do with a laugh.
We're just going to keep out of ditches. That's all we'll say.
All right.
Any further comment from anyone, either on condition 15 specifically, or about the potential process outlined by Mr. Innes of a further draft list of conditions and then people responding to that in their closing submissions? Okay, we'll come on to condition 16, which relates to borrow pits. I think here there's agreement between the council and the applicant, but Mr. Shaw, you had a comment here, I think, regarding phone calls and blasting and so on. Do you want to summarise your position on that, and then I'll come back to the applicant?
Yes, sir. I think the problem here is that we are living in quite remote locations, and things that go bang in the night tend to make us a little bit jumpy. We're not very far away from where that poor woman's body was dumped that was murdered by the wind farm employee not so long ago. That's only a matter of 3 or 4 miles from where I'm sitting at this point. So we tend, when there are noises, when there's shooting or noises like that at any time of the day, and the forestry haven't told us about it, we tend to report it to the police and the forestry. So I think that's part of it. But the second part is that actually, in this modern day and age, a lot of our properties have a fair degree of technology. Certainly this house relies quite a lot on technology to manage the heating systems and such. we might want to actually protect that from the vibration, because these blasting in the, call them borrow pits, they're quarries really, can travel through the ground for quite a long distance. So we have concerns. We'd like to know in advance when the blasting will take place, and we'd like to know, we'd like somebody to contact us afterwards to be sure that there hasn't been any damage.
Mr. Bell, do you have any view on this?
Yes, sir, thank you. I think firstly, the blasting wouldn't be undertaken at night. The hours are carefully restricted in the condition for that activity. And the EIA assessment that's been undertaken did examine vibration as a result of blasting. And it was very early on ruled out based on no evidence in the assessment to suggest that effects could result from that activity. I think also it's worth noting that my understanding is Forestry Land Scotland does work some borrow pits on the land at the present time, and there's no evidence to suggest that that has been an issue for residents causing damage to properties. So against that background, in particular the EIA assessment, it's highly unlikely that a small-scale blast 1 mile from properties would have vibration effects. And the condition does contain a monitoring scheme for blasting, and it can include for public notification if that was felt necessary. I think the other point of note is that SPR does, as standard practice, have a named point of contact during the construction of the wind farm, which the community councils and other residents would have information on. And in terms of, for example, the days on which there may be blasting, that could be a matter that could be communicated as well through that channel. So with those provisions in place, there's no necessity for anything further or amendments to that condition, I would suggest.
With respect, Mr. Innes, I just don't agree. Shooting takes place day and night. The forestry always advise us. If they're going to be blasting in their quarries, they always advise us in advance. And without wishing to be rude, the mere fact that your client's environmental impact assessment says it won't cause us a problem doesn't actually allay my fears in the slightest.
Right, well, thank you, Mr. Shaw. I've noted that. I'll have to think about that. I think that probably covers item condition 17 as well. If there's no further comments on that, then we can come on to item 18, condition 18, the ecological clerk of works. And Mr. Campbell, the council here is seeking a bit more specificity in this condition.
Yes. I might defer to Mr. Edgar on this one, I think.
Mr. Edgar.
18.
Yep, thank you. My comments are made in the light of the experience of being the person that has to actually monitor these conditions and if necessary enforce. And I've found in the past, because there's so much information submitted in EIA, that it is much better to be specific in the condition about what it is we're expecting the cow to actually cover, and it's really just it's for that clarification in practice when this goes into the real world. It's just to have that level of specificity is very helpful to us as officers.
And when it says here that you say e.g. Conditions 19, 20, 27, 29 and 30, there may be others. That's not necessarily an exhaustive list.
At the time of reading the first draft of these conditions, those were the ones that I identified as being the most significant one. So it would be exhaustive in that sense, but I would certainly appreciate the chance after a sort of final draft of the conditions approved just to revisit that.
Thank you. Mr. Bell.
Yes, so I think the terms of reference for the Clerk of Works are purposefully set out as they are to avoid that pick and mix approach, if I can call it that, that would potentially miss things out. So by trying to be precise, the exact opposite may be achieved. So the way in which it's worded at the moment seeks to provide a wide-ranging scope, and that has to be agreed in writing with the planning authority. Now, there is one additional term that could be added in, I think, which can hopefully further address what Mr. Edgar's saying, and I recognise his point. So in item A on the condition, where it says impose a duty to monitor compliance with ecological and hydrological commitments provided in the EIAR and other information lodged in support of the application, you could add in after application and any relevant conditions. So just add in there and any relevant conditions, and then it will go on to then full stop, take out construction environmental management plan. That allows the scheme to, it's a trigger point for the scheme to look at any other relevant conditions that need to be put into the specific scope. So hopefully that minor edit can provide an assurance to Mr. Edgar, that there will be a comprehensive review of the necessary items to be examined in the overall scope for the ECAR.
Would that help at all, Mr. Edgar?
I think it would. Take the point that there is a point at which we can sit down with the ECOW and actually agree in writing what it is they're going to monitor and report back on. So yeah, no real further comments to make.
Thank you.
Further matter for sorry, so there's one further matter arising from the Ecological Clerk of Works. There's currently an inconsistency between the micrositing condition and condition 18. The micrositing condition talks about an environmental Clerk of Works, and the current condition here has got a heading Ecological Clerk of Works. Whatever we use, the term must be consistent between the two. And I know that Nature Scott are taking the view now that whilst we originally used to call it an Ecological Clerk of Works, there are parts or specifications within the role which also incorporate wider environmental matters such as water quality monitoring. And so it is unlikely that one person would do the full remit, although it is likely that the person on the ground who's doing a lot of the monitoring is likely to be an ecologist because of the nature of the issues that arise. But there will be backup from whoever is appointed as the Clerk of Works, whereby the skill set will require other matters to be done. So I just want to say there is an inconsistency at the moment. It needs to be consistent. Neither it's the Environmental Clerk of Works or it's the Ecological Clerk of Works. Nature Scott identify that they prefer the word Environmental Clerk of Works now, and insofar as we're dealing with matters, you can see from the scope of work that it includes the hydrological commitments as well, and that may well necessitate expertise professionally that goes beyond that of an ecologist. So there does seem to be a certain logic to suggesting that it is now probably more properly termed an Environmental Clerk of Works. And that just makes sure that the proper scope of the services that are being deployed is not somehow constrained or sought to be constrained by the character or title that we give it. And equally, whilst a lot of the work is ecological, there will be that add-on of those other services that are required, and will no doubt form part of the scope that formally has to be approved in terms of the discharge of condition 18. So as I say, we're not particularly fussed about what it's called, but agree that it does probably go now beyond purely the ecological, and it could be called an environmental clerical works.
Yeah.
Right. Yes, I think I agree. The important thing is to be consistent, and inevitably there'll be a named individual, but they'll be calling on expertise from other disciplines. That's 11 o'clock now, so I think we'll take a short break, and we'll come back at 10 past 11, if we may, please. Thank you. That's 11:10, so if we can make a start again, please. And I think we've come on to condition 19, which relates to the construction and environmental management plan. Appears to be agreed between the council and the applicant. I had a question about item H, the peat management plan, and I noted that Nature Scott was seeking a separate condition, seeking a peat management plan. But I wondered if that was covered here anyway by item H. And I also noted in SEPA's response to the application, they were seeking for a condition requiring the submission of a complete peat depth map. And I wondered if that could be just included in item H as an additional component of that, if indeed that goes beyond what we already have. I don't know if there's anybody on the applicant's side who can comment on those matters regarding the peat management plan. Mr. Bell. Mr. Bell.
Yes, sir. I think we're going to come on to, there was a point I was going to raise later that the peat management plan, as you rightly have spotted, is already covered in a later condition. So that later condition can be struck out, I would suggest, and we include it within the SEM. I'm struggling to find the exact number, but we're coming on to it shortly.
Fine, thank you. And Ms. Jack, if you're with us, would you be content for the reference here to cover Nature Scott's concern?
Yes, sir.
Thank you. And can anybody help me out on the SEPA requirement for a complete peat depth map? Or I think we already appear to have something of a peat depth map in the EIA report, but maybe SEPA's seeking something a bit more fine-grained. But we can leave that for now.
Yeah, comments. Yeah, just to say that in terms of the peat management plan, to get to the excavation volumes and the handling, storage and reuse, you need to have an understanding of the peat depth, or otherwise it won't work. So all these figures require you to understand the peat depth. So I'm presuming that that will all be incorporated in the peat management plan as part of the evidence base for supporting the calculations on the peat depth and where it is and how much is being taken and the volumes, etc. One really couldn't do that without having a peat. And obviously we will at that stage have more information on the ground investigation. So it would supplement the material that's already been submitted in terms of we've got borehole depths across the site, but we will obviously in advance of construction be doing more ground investigations. That's a standard part of the development process. So that would supplement the material that we already had and coming to the information to be submitted as part of the peat management plan, because you cannot work out the handling and storage and reuse until you've, in terms of the storage levels, until you understand the levels of peat that you're likely to have to deal with. And equally, over the key infrastructure matters, we want to have a very clear understanding of the exact character and nature of the material that we'll be passing over or undertaking works within. And so the ground investigation works would inform that. So I think it all goes into the peat management plan, and that's the right place for it. And it's probably the details of peat depth, or whether it's a map or whether it's details, we've got the details having to be required here anyway.
Fine, that's enough for me there. Thank you. And I also note item J, site illumination is mentioned there, so that can perhaps pick up on some of the items we picked up on earlier about well, there's an opportunity there for the council to have an input into the way the site is illuminated.
I had one. Sorry,
yes,
sir. I was just going to say I had one separate point on point I, which is the water management plan, and it arises from the evidence that was given at the hydrology and PWS session. Now, having heard the council's evidence, we have serious concerns about the way that the council says impact on hydrology and private water supplies should be established. And that will form the basis of a claim for expenses against the council in due course. Now, we're concerned that at the point of attempting to discharge the condition, we are faced with exactly the same problem, and that we have an opaque objection from the council's environmental health officer that requires us to deal with what Ms. Quinn described as the need to consider everything. And what we are therefore proposing is a highly unusual step, which is amending the condition so that rather than referring to a water management plan covering water control, etc., it would be a water management plan based on relevant published guidance and methodologies. And then the condition would continue. And we feel that in the context of this case, that is essential because the council was unable to explain during the inquiry session how water quality protection issues would be dealt with. So we think that that change is necessary.
Thank you, Mr. McLeod. Mr. Campbell, and your response to that. I think you're on mute, Mr. Campbell. And you're coming through very quiet again. So whatever you did to fix it last time, if you could do that again.
Can't do it quickly, sir. I'll have to change my device, and it takes a few moments. So can you move on to the next point and come back?
Very well. I think Mr. Brown probably wants to come in on this condition as well.
Yes, sir. Thank you. Sir, the airport as an aviation stakeholder has drawn attention to CAP 1096. In essence, sir, this is a scheme for notification of the use of cranes to the CAA, because obviously the cranes can have an effect upon air navigation. The CAP document is not in full effect yet. It's anticipated that it will come in no earlier than the 1st of April 2022, although there's a trial period running between the 1st of October this year and 31st March next year. The airport has drawn it to your attention, sir, as I say, purely as an aviation stakeholder. The airport accepts it has no direct interest in the application or enforcement of this procedure, so it's entirely a matter for you, sir.
So is the suggestion that this notification would happen anyway without the need for it to be included in a condition because it would be required by this other regulation?
Well, sir, that's a point I don't know. I'm not sure whether the applicant would do it automatically or whether its contractor would do it.
Mr. Innes, can you help us on that point?
Yes, I think condition 15 deals with it because we've got to notify the date of commencement of construction, anticipated date of completion, heights and locations and latitudes of all turbines and meteorological masts, descriptions of all structures over 90 metres high, and the maximum extension height of any construction equipment. So the notification procedure is already encompassed within condition 15. And insofar as condition the SAMP's concerned, it's primarily not dealing with these matters. And the fact that there's a future cap coming in doesn't stop the fact that we've covered it off in condition 15 about the notification. And equally, if we're required to carry, if we need to conform to other legislation or requirements, then you wouldn't duplicate it in a SEM. So, as I say, I think we're covered off with the condition 15, which has got the notification requirements. And clearly, if caps come in, we'll have to comply with those measures. I think it's already dealt with, and it wouldn't be necessary to change the SEMP at this stage on Mr. Brown's very helpful intervention about future changes that might occur, because we've covered it off already. Thank you.
Thank you. Mr. Brown, is that anything
Yes.
from you?
Yeah, just one observation, sir, that condition 15 is drafted at the moment, by my understanding, doesn't include reference to the CAA.
Well, perhaps that's something the applicant can look at in their drafting of the.
We'll probably just add them into 15. It makes it easier. At the end of the day, everyone's getting the same information at the same time. It's just another an email address on the notification. So I'm sure that's the proper way to deal with it. So we'll add them in.
Yes, thank you. That'd be helpful.
Thank you.
Mr. Shaw, I think you did comment on this condition.
Just to say, sir, that the last comment by Mr. MacLeod frightens me quite a lot, because there's a real world out there. And it's not simply enough to produce some kind of a plan based upon published information. They must investigate the private water supplies properly and establish the catchment area and avoid damaging it. It's apart from the fact it's a criminal offence to damage it, but nobody seems to care about those things. This is just quite fatuous to suggest that by relying on published information, they've discharged their responsibilities.
I'm not sure that's exactly if I come back to Mr. MacLeod.
Yeah, I think I was going to say exactly what you were about to say, sir, which is we're not suggesting it should only be based on published information. We're suggesting that the preparation of the plan should be based on published guidance and methodologies. In other words, we would take the combined knowledge of experts from around the country who have published methodology and guidance on how these things should be done. We would then apply that guidance and methodology to the site-specific aspects of this development. What we are keen to avoid is the suggestion that the water quality management plan is based on a notion of considering everything, whatever that means. And what we're keen to ensure is that the water quality management plan is based on sound scientific principles, albeit that it would very much be related to the site-specific aspects of the development.
Well, my comment on that is I'd really like the water management plan to be based upon the reality. I don't really care too much about experts and published information, because if my water supply dries up or becomes poisoned, we have to leave this property. So it doesn't really satisfy me for you to say that you use the foremost experts in the country and their and whatever systems they promulgated. What I actually want to see is a proper on-site investigation to establish where the private water supplies to these properties actually comes from. Now, how you do that, I don't know, but I don't believe that anything else is adequate.
Thank you. I think we'll move on. Mr. Campbell, are you back with us now?
Yes, I hope so. Can you hear me all right?
Yes, much better. Thank you.
Thank you. I don't know what's wrong, but I'll take steps to fix it in due course. I think the first thing to say is that it would have been preferable to have this proposed change intimated in advance, so that the council could take advice from its officers and consultants. However, that being said, our opinion is that subclause I is an adequate condition to impose upon this part of the contents of a CEMP. It isn't something dreamt up on the hoof. It's taken from might be described as standard conditions for wind farm development. I'm struggling a little bit to see how that's any different from Miss Lobbin's evidence, but obviously I'll have to go back and look at that. And secondly, how reliance only on what was the language used, relevant published guidelines and methodology, could be taken necessarily to include local conditions. One has to therefore say that we endorse what Mr. Shaw said. Now, we won't solve this problem today, and what I would invite you to do, since my officer is on holiday this week and not available for consultation, is to postpone your decision on this matter until any date that you choose, reasonably placed, so that I can take instructions and come back. So to summarize, 1, regrettable this was not raised before. 2, the draft condition is adequate. 3, given what Mr. MacLeod says, please allow some time for the council to take advice upon the proposed change. And perhaps 4, if Mr. MacLeod could tender a draft revised subcondition I, then we could all be sure we were looking at the same thing.
Well, I can capture this with the process that we outlined earlier, whereby the applicant would supply a revised list of conditions by some date in early July, 2nd of July or 4th of July or something. And then other parties could pick that up in their closing submissions.
Yeah. Mm-hmm.
Can we move on then to comments on condition 19? And condition 20 about fish management plan appears to be agreed. Any comments on that? And condition 21 on the drainage strategy. Any comments on that? Then we'll come on to condition 22. And Mr. Shaw, you had some concerns here that the exceptions listed in the second paragraph were too wide.
Yes, sir. I think it was. I think the basic.
Mr. Shaw, I can't hear you.
I'm sorry. Is that any better?
Yeah.
Yes.
Okay. Well, then it says out with these.
You've disappeared again, Mr. Shaw. I can see you, but I can't hear you.
Yeah, is that any good? Hold on, let me stop the video.
No, that's fine now.
Okay.
No, you've gone again now. We can't hear you, Mr. Shaw.
Is that any better at all?
Yes, that's better now.
Okay.
But then no, you faded out again, I'm afraid.
Okay, I'm trying to read it and talk at the same time. Multitasking isn't the best. Basically, the second paragraph, in my opinion, if you can hear me, seems to allow virtually any kind of work to be undertaken, because turbine erection pretty much includes everything that they're planning to do. and similarly with some of the other words. So I would like that to be a tighter clause.
Thank you. I mean, Mr. Shaw, having brought this to my attention, it does seem rather broad-based, Mr. Bell, but can you provide any reassurance or suggest any changes here?
Yes, I mean, firstly, the conditions are standard as they're expressed, and the actual second paragraph is fairly narrow when it's examined in terms of the specified activities. So the applicant's position is that this provides the appropriate balance between allowing things to get on during construction appropriately with that specification and adequate levels of protection of immunity.
But under this condition, turbine erection could happen in the middle of the night.
Well, that wouldn't happen in hours of darkness, but there may be certain activities related to that that by necessity need to happen at that stage.
Thank you. Any other comments on this condition? Good. Come on to condition 21 about HGV movements. Any comments on that one?
Well, thank you.
And then condition 24, traffic management plan. Yes, now here we get into this issue of Dumfries and Galloway Council and their interest. I'm just wondering if, I mean, in my mind, if the condition talks about the planning authority, then that would be the appropriate planning authority, and there are two planning authorities involved here. So I wasn't sure that I needed to list the two planning authorities separately, but I'll take people's advice on that. Mr. Bell?
Yes, so I think we're aware that there would benefit in making an amendment to the condition as compared to the one you've got before you at the moment. So the suggestion is that in the first paragraph, it should read approved in writing by the planning authority in consultation with Dumfries and Galloway Council. So we retain the discipline in the condition set that the planning authority is the council here today, but in recognising that the access is within the neighbouring authority, that there is a consultation undertaken with DGC, with Dumfries and Galloway, and that provision would also be reflected in the following conditions 25 and 26.
Mr. Campbell, does that sound sensible to you?
It sounds sensible. I just wonder about the question of enforcement. If South Ayrshire is required to consult with Dumfries and Galloway, and then subsequently an enforcement issue comes up which is located in Dumfries and Galloway, presumably they have sole jurisdiction. I think I want to defer to Mr. Edgar on this. Otherwise, the proposal that Mr. Bell has articulated sounds sensible.
Thank you. First of all, I put the comment in just to draw attention to this fact that this development straddling two planning authorities. The point Mr. Campbell's just made there hadn't actually occurred to me before, that if there is an enforcement issue, South Ayrshire Council would not be taking enforcement action in Dumfries and Galloway. What I do wonder actually if there should be some means by which Dumfries and Galloway approve this plan as well, the bit that lies within their authority, rather than us consulting them. I wonder what I can't confess to be able to give a legal opinion at all. I'm not sure what the legal status would be if part of the development site's within a planning authority's area, a condition's being imposed on that, should that planning authority not be the authority that gives its consent and also does the enforcement if there was a requirement for it? I'm not entirely sure the answer to that is.
Perhaps a way forward today might be for you to direct my clients to consult quickly with Dumfries and Galloway Council to see if they would wish to be involved in this, or whether consulting them would be sufficient for their purposes. I'm sure that could be done on the phone.
That sounds like a good way forward. Yes, and we can pick that up in the exchange of submissions that we identified earlier. Mrs. Spence.
It occurs to me that, as I've previously pointed out in other sections, that if the applicant were to sign the entrances to their the way that they're going onto the site a lot better than they have previously done. It's taken about 5 years and they still have not got a clear entrance to the Kilgallick way that they're planning to use for the construction of Clay. And I would imagine that the similar entrance that they would need to use to get to Clauchrie has not even been thought of yet. And signage was a considerable cause, or the lack of signage was a considerable cause of a lot of grief with local residents, because numerous huge trucks landed up unsuitable private driveways and caused a lot of damage and a lot of annoyance. I mean, it's not beyond, if you look when you're travelling and you're just over the border at the Kilgallick entrance at the moment, there is a sign now that says Kilgallick. There is a bridge which, if you're driving a large truck, needs your entire attention immediately on that point. So whether you're approaching it from the south or the north, your attention is on the bridge. You do not have a chance to see that that is probably the entrance that you're looking for to deliver your huge lorry of stuff. And that has been a point of contention for years. The applicant, you would think, I mean, the kennels that you will see on the road have perfect signage so that it's read from either direction, north or south, and you notice the kennels and you turn into the kennels. So why the applicant cannot do that beats me, because it's such a simple thing that can save so much trouble. And I think it is largely the fact it's this, oh, we're just the masters, we've got permission to do everything. The local residents don't matter, and it really is very, very annoying and causes a lot of grief. So if the applicant could take note and even sign their entrances, this would avoid at least 50% of the damage and annoyance that they cause. And they just
I think this is the item. I totally take on board the point you're making, and item C does talk about signage having to be agreed. So I think it's maybe for the council, or in consultation with Dumfries and Galloway Council, to pick up on that, and obviously the applicant listening.
Or maybe they could sort of catch up with the signing that they should have done previously when they were constructing Kilgallick, and work on from there. And before, they must have the signage in place before any work should start. Would be a good thing.
Okay, thank you. Any further comments on Mr. Shaw?
Thank you, sir. Yes, when you come for your visit next week, I will show you exactly where Dumfries and Galloway ends and where South Ayrshire starts. I have a request for an additional condition, being that access be maintained at all times for the properties, for the occupiers and of the properties along this road. There is a diagram in my further written submission about access and traffic, and I'm aware that the applicant has responded that of course they would keep the access open at all times, but unfortunately what we have seen with previous developments is that turns out to be a little bit of a horse promise, and I would like it to be a condition that is enforceable.
Thank you, Mr. Bell. Is that a possibility from your perspective?
Yes, sir. I think it's already included. Really, the traffic management plan in condition 24 will deal with maintaining safe vehicular access at all times. So that is a provision it will include for.
Could we expand that to say to private residences? Including to private residences, would that cause you any difficulty?
If you could give me a moment, sir, just to take instructions, just for.
Yes, by all means. Thank you. Anything more on conditions? Well, can take perhaps all these together, conditions 24, 25 and 26, the access conditions. Come on to condition 27, the habitat management plan.
So just to
yes, Mr. Bell.
Sorry to interrupt. Just to given its private access matters, it may be that is a provision that could be included in the SEMP condition rather than in the traffic management plan. So that is something we can look at in terms of the further draft, just to make clear how we would word that.
The point at issue, sir, is quite simply that somehow or another emergency vehicles have to be able to reach our properties. Notwithstanding the fact that we might want to go shopping one day, this is actually quite a serious issue for us. So I would be grateful if it could be addressed somewhere within the conditions, so we have something we can hang our hats on when it goes wrong.
Yes, thank you. I think the applicants may be thinking about some amended wording to accommodate that. Coming on to item 27 then, and Ms. Jack, Nature Scott were proposing an addition here.
Yes, that's right, sir. Nature Scott were concerned to ensure that deer management was addressed somewhere within the conditions. Nature Scott considers it likely that deer will be present on and using the development site, so continues to recommend that an assessment of the potential impacts on deer welfare, habitats, neighbouring and other interests, for example, access and recreation, road safety, should be presented. Nature Scott's concerned to ensure that if the development would or could result in significant impacts, a draft deer management statement should be provided, setting out how those impacts would be addressed. Nature Scott doesn't have a strong view on whether this should be addressed in a separate condition or included within the habitat management plan condition, as has been suggested by the applicant. Nature Scott has proposed some wording. There's been some ongoing discussion between Nature Scott and the applicant in relation to this, and the most recent wording proposed by Nature Scott is that the deer management plan or habitat management plan, depending on whether it's dealt with by way of separate condition or incorporated within the habitat management plan condition, in either event, it should set out proposals for long-term monitoring and management of deer using the wind farm site, including assessment and monitoring of the impact of deer grazing and trampling on habitats. The plan should identify how deer control will be adjusted to reduce negative impacts. Proposals for long-term management of deer will include collaborative deer management with neighbouring landowners and occupiers of the wind farm site, and they would be looking for the plan to be implemented in full for the lifetime of the development.
Thank you. We have draft condition 28, which covers deer management already. So I would have thought those provisions could go in potentially in there. I wondered.
I think, sir, that the applicant had been suggesting in further discussions that have taken place since this version was submitted to yourself, that perhaps it could be incorporated within condition 27 rather than a freestanding condition relating to deer management. As I say, NatureScot doesn't have a strong view on whether it's a freestanding condition or incorporated within habitat management, so long as the matters that they would wish to see covered are incorporated either way.
I see. I mean, I do in some ways wonder what the relevance of this is to the development. I don't know if NatureScot could explain that, if whether this is I mean, presumably there are deer on site already that require management, and what the link is to the existence of turbines on the site.
I think that the concern is to ensure that if the development has an impact on the way that deer are using the site, that there would be the ability to adjust the management of deer to take account of any negative impact that is being caused as a result of the construction work phase, as well as the operation phase. Obviously, when works commence for construction, it's likely that there will be disruption to the way that deer are currently using the site, and NatureScot are concerned to ensure that any negative impact that arises as a result of that is able to be taken account of.
Okay, thank you.
It may be that Ms. Kinnis wants to come in, and can I just check with her that I've covered everything off that she would want, and that she doesn't have anything that she wants to add in on that?
Yes, I think that's everything we wanted to say. There's also the delivery of the habitat management plan, and deer could have an impact on that area. But the reason for wanting it is as Jennifer described.
Thank you. Mr. Innes.
Yes, sir. Just key off, the deer are already managed by Forest Land Estates. So the fact is that there's already deer control being undertaken, and there is a limit to what the applicants are capable of doing within the wind farm site. I mean, our primary opportunity is to enter into lease obligations to lease land to both to operate ultimately the wind farm. So insofar as that's already happening, we recognise so in terms of general deer populations, we don't feel that there has been demonstrated that there's a necessity to go over and above what is currently being done on site with deer management, and it would probably be essentially wrong to interfere with deer management proposals or activities merely because we were doing construction, because that would be temporary. So we don't feel that it's necessary to undertake it. But what we do recognise is that part of the habitat management plan, which is this habitat restoration, could be impacted by activities of deer either grazing or trampling on the habitat that we're trying to recreate. So our suggestion is that effectively that's the means behind this deer relate to the development, in the sense of there is the potential for deer to impact upon one of the mitigation enhancement programs, which has essentially been identified by the applicant and to which we want to deliver. And in that context, what we propose is that effectively condition 28 be incorporated in part into the habitat management plan. But really at this stage, what it should set out is the habitat management plan shall set out proposals for long-term monitoring of the impact of deer grazing and bleak trampling on the habitats within the habitat management area. Now, that's the first precursor to potentially action being taken in terms of the habitat management plan. But as you'll see from condition 27, the approved HMP will include provision for the regulatory monitoring and review to be undertaken to consider whether amendments are needed to better meet the habitat plan objectives. And it's in that context that we say that if there needs to be deer management, it would follow upon the work which had been done in terms of the monitoring. So we say that the HMP is the right and proper place in which this should exist. And at this stage, it's sufficient to have the long-term monitoring identified and required in terms of the HMP. And the ultimate consequences is a matter to be set out in the HMP, which will no doubt potentially identify circumstances in which intervention may be required and how that may occur. And we would obviously engage with the other interests to achieve that. But that's the context of where we think it should lie at the moment. And we don't think a broad-ranging deer management plan is relevant and appropriate at this stage. We believe that it should be focused on the HMP, and certainly that's how the applicants would propose the matter be dealt with.
Thank you, Ms. Jack. Any further comeback on that before I go to other people?
Only to say that if you are minded to take the approach that Mr. Innes is setting out, that Nature Scot would be keen to see wording included that would provide specifically for collaborative deer management, purely to ensure that that is understood to be the approach that should be taken, taking into account that the interests of Forestry and Land Scotland, etc. I don't think, unless Ms. Kinnis wants to come back with anything else, I think we probably covered the position that we would want to see in our earlier submission.
Yes, I agree with that. I think we want it to relate to the whole site, because it's not just habitat impacts that we're concerned about in terms of deer. It's also welfare issues, and the wind farm is a big infrastructure project going into a big forested area, and what we accept that Forestry and Land Scotland do carry out the management, but some kind of collaboration will be necessary in order to manage deer through your processes. That's why we wanted it to be a bit more all-encompassing than just impacts on the habitats in the habitat management area.
Thank you. I think again, we'll see the wording that the applicant comes up with, and then there'll be an opportunity for you to comment on that. Mr. Shaw.
Yes, I'm sorry, sir. This just sounds like moaning, but I'm astounded to sit here and listen to people speculating about whether or not there are deer in the site that's been chosen for Clauchrie Wind Farm. Why on earth does nobody ask the locals? That's all I want to say.
Yes, and Ms. Kendall.
Agree with what Mr. Shaw says. In the SPR application, it was said that there were no red deer. You only need to ask Forestry and Land Scotland for their cull figures to find out that there are red deer in the area. I'd like to just comment on Mark Hill, and that there is secure deer fencing all the way around Mark Hill now, which was only put in around 4 years ago. That, I agree, may influence their habitat management plan in what they're trying to recreate there, but that was not in the application at first, and subsequently that will affect other mammals and wildlife in the area, such as foxes, which also were not identified in the SPR application, but they are here. And it will also affect, if Clauchrie were in the future to be fenced off for deer management, it would affect recreational access and the ability to walk along those areas. Although at Mark Hill, I know they have gated access so that people can access that. They're only in specific areas. So if you wanted to access for recreation, for walking, running, whatever. You wouldn't be able to do that if it was deer management in terms of fencing.
Yes, all these matters need to be considered in the round. Yeah. Yes, I mean the habitat management plan would cover presumably the range of species, and it would also need to be prepared in consultation with various bodies. But I do take the point about other interests like recreation. Any further comments on this condition? So I think that also covers condition 28, which was the previous deer management condition. Condition 29 is around bats. Any comments on that one? And condition 30, species protection plan. Again, Nature Scott, I think, has some proposed additions to condition 30.
So, if I may insist that the applicant noted Nature Scott's comments and decided that, in fact, the condition might be better formulated in having a paragraph that deals with the species protection plan and a second one dealing with the bird protection plan, broken up and taking on board comments made by Nature Scott. So in that context, what we are proposing or would propose is to provide some amended wording which makes it a bit clearer, and we acknowledge that there was ambiguity in the context of the initial drafting in respect of this particular condition, and we felt that it was better that rather than trying to slightly adjust it, to separate them out and have clear text to support both.
Good. So that sounds like discussions and agreement is underway. Is that match your understanding, Ms. Jack?
Yes, it does, and we've seen some updated wording that we're broadly content with. So that's a matter that should be capable of being ironed out with the updated version of the wording that will be provided following this session.
Thank you. Any other comments on condition 30? And then condition 31, the water quality monitoring plan. Mr. Shaw, again, I think you had a proposed additional condition on this topic.
Yes, sir. I would like to see all of the residents being provided with a telephone number which is manned 24/7/365, so that when we identify a problem, we have a point to contact, because and this would apply for a number of areas, be it the access, be it the damage to the private water supplies, which we think is quite likely, and any other problems. We would like to have a specific telephone number that we can always contact.
Can the applicant comment on that, please?
I was going to come in on the private water supply aspect of that, sir. So we don't believe that's necessary, and it's not to say that we're trying to avoid contact with the residents. The point is that the issue will be addressed as part of the the private water quality monitoring condition, and that's number 39. And it's maybe worthwhile just having a quick look at that at the moment. So condition 39, if everybody has that, is suspensive. So no commencement of development until a method statement for sampling and monitoring of private water supplies has been submitted to and approved in writing by the planning authority, detailing all mitigation measures to be implemented to verify the quality, quantity and continuity of water supplies to the identified properties at the date of this consent. Now, we would expect that as part of that method statement approval, there will be requirements in terms of notification and so on. But that's a matter that can be addressed once the detail of the water quality, the private water supply monitoring regime is established and put to the council for approval. My only other comment on 39 while we're on it is we would like to see a similar change made to the one that I suggested for condition 19I, so that the private water supply methodology is to be based on relevant published guidance and methodologies for the same reasons I mentioned earlier on.
With respect to that, doesn't really answer the question. What we want is a point of contact so that whether it's private water supplies, shadow, flicker, access difficulties, we want to be able to get hold of somebody and not go through the usual procedure where you have to hold for ages and ages and wait until an operator becomes available. It doesn't seem to me to be an unreasonable request if the applicant is confident that they're actually not going to do us any damage, because that phone will never be used.
Yeah, just to say that one of the things that we could probably add to the SEMP, because that's I think where that should properly sit, is a communication strategy, and we'll probably put a bullet point in the revisal to cover that. And insofar as that operates, is it does create a two-way flow potentially of information between what's happening and also if there are issues that they can be resolved, and that there is an identified party who will receive that information and act upon it. We do have a lot of experience in working with these systems. They do work, but what I can't guarantee is it's 24 hours a day. I mean, that is a demand that's probably beyond what we can deliver, but we can certainly deliver a strategy for communicating with those most potentially directly affected by the construction process to ensure they know what's going on and that they have a liaison. That is something which is positive, and equally that can actually, I mean, the experience is, rather than phoning an authority and complaining about something, I understand and our clients understand that really what people want is the matter sorted. And that means that we're able to respond quickly to any concerns or matters that arise, and that communication is effective. So we understand the importance of that communication during construction, and I think that probably should be reflected in perhaps an additional bullet point to the SEMP. And it often proves the most effective means of working through local construction issues. And we do have a direct experience. FPR have an extensive experience in utilising these in their major infrastructure projects that they've been working on. And it's proved to be in a really effective way of sorting out local issues before they escalate. So I think we'll probably put something in the SEMP to cover that. But what I don't think is reasonable as a 24-hour day phone line. That's probably beyond what can be delivered.
Sorry, sir, I don't understand what a SEMP is.
The environmental management plan. It was a requirement, it's one of the earlier conditions. So I think what's being suggested is an extra component of that would be this liaison point. But it doesn't sound like that will fully satisfy you, Mr. Shaw. But we can wait and see what the applicant comes up with, and then you can comment appropriately on that.
It's condition 19 for Mr. Straw.
Condition 19 for the SEMP.
I would add, so there is increasingly part of larger infrastructure projects for that liaison to be put in place, and it is usually pretty personal and ensures that there is cover and that you're dealing with the same people, and that if concerns are raised, that they are dealt with, and there's a proper means of communication through to what's going on site. The reason why the SEMP is the right document for that is that's the document which effectively is the, if you like, the code for dealing with the construction, and it's a matter which a document and all the requirements of are very clear and close to the contractor. So that's why that's the best place to put that, is that it has that very specific role during the whole construction process, and it's also tied in to those obligations that also pass through contractually to the contractors. So as I say, we would be keen that that's the right place to do it and it gets the right prominence there and it doesn't get lost in another condition. The sense of essentially how the project's going to be constructed, and where there are those aspects, it is far better it goes in that document and the SEMP discharge than being separated off elsewhere.
But we need something which continues throughout the life of the project, not just the construction phase.
Yes, that was going to be my question. Would the SEMP only cover the construction phase, or would it be a longer term? Could it include provisions for longer term liaison?
It would, and there is separate. It is right that there's a separation between the construction and operation. Once the asset becomes operational, it's passed to a separate part of the business to own and operate, etc. And there'll be formal handovers, and equally responsibilities change from that of the those constructing to the site management of the operation. And again, I don't see any reason why we can't have some form of communication, particularly in relation to issues that arise. So we can perhaps find a way to put it into operation, but the construction really must be in the Kent, because that is the correct place to ensure that it's captured and built into the construction process.
Okay, so there might potentially be two references then, one for construction and one for longer term. Ms. Crosthwaite.
Yes, thank you. I think this is a very important point, because this does have to be ongoing during operational. There must be some point where, if there is some kind of emergency, some kind of fire, of reporting quickly to the necessary people. And so surely the people like Mr. Shaw, the residents and the council, can be included in this. And I do think it should be a separate condition that is throughout the whole lifespan, construction and operation.
Thank you. And Mrs. Spence.
I should point out that Mr. Innes's conception of the current situation is rather aspirational than what is actually happening. I know that every time people have a problem, the problem is exasperated by the fact that SPR are very slow on the uptake and are most reluctant. I mean, every private road that has been invaded by the delivery trucks, for instance, has had at least 3 delivery trucks stuck up and doing damage before they managed to put a sign at the end of the road. And of course, as I was saying earlier, the signage that they needed just simply for their own deliveries, which you would think that they would want to make as easy as possible, they just haven't done. So how can we rely on what they say? Because they don't put it into operation.
Thank you. Any other comments on condition 31? Then we'll come on to condition 32, access management. Any comments on that? Condition 33.
Sorry, just to clarify that in terms of the access management condition, that also includes for the details of parking provision, which would be included in terms of the car park to be retained following the cessation of construction works, and in particular the construction compound. So I think that had been raised, I think, in a question perhaps by you in one of the inquiry sessions or hearing sessions. I wasn't at that, but just for clarification, that the access management plan would include for matters such as parking provision as well.
So that's an addition that will be made to this condition.
That's correct, yes.
Thank you. Condition 33 is archaeology, and the council's come up with an alternative wording here. Perhaps I'll start with the applicant or Mr. Bell as to the acceptability of the council's. Are you happy with the council's proposed alternative?
No, sir. I think the condition as drafted relates to the access track, and that is where the EIA assessment has identified the interest, and of course there is the cairn toward near the entrance. So the condition that's proposed needs to be relevant to the development to be permitted. So it's precise insofar as it relates to the EIA findings. The council seeks, I think, with their amendment to require the observation of agricultural works to be during the construction of the overall development. There's no specification of any parts of it. So that would include all the forested area, which would not be proportionate or reasonable given the appraisal undertaken. So the condition seeks to be precise on the basis of the information that was set out in the application. The access track is the main sensitivity, and it is within the Dumfries and Galloway Council area. So in short, the condition doesn't warrant a scope of the whole area, and that would be the applicant's position.
Thank you. Mr. Campbell.
I'll ask Mr. Edgar if he can comment first for me.
Mr. Edgar.
Yeah, sorry, my cursor disappeared off my screen there, but I've now found the mute button again. I think what I'd want to do is actually refer back to our advice comes from West of Scotland Archaeological Service. It's in the back of our mind that they had identified other archaeological sensitivities within the site, but I would really like the opportunity to go back and just reread their consultation response and possibly discuss it with them. I'm not sure they've agreed that the only archaeological sensitivities are on the access road. That's something I really like to check again and be able to reconsider.
Mr. Bell is quite right to say that the condition relates to the extent of the inquiry undertaken by the applicant. And of course, undertaking an inquiry about archaeological remains in a forest is exponentially more difficult than on an open track. The purpose of the condition as it now appears is to cover the discovery of archaeological remains of any significance during construction of the development. It's very difficult to see why that should be objectionable. Let's suppose, for example, that in the course of the felling of the forest or the excavation of turbine bases, a discovery is made of, I don't know, a chambered cairn or whatever, then work is going to stop. And first of all, the question will be asked, is it of any significance? And if the answer is in the affirmative, then the Archaeological Service will come and look at it and either stop work completely at that location or recommend stopping work completely at that location, or engage in some sort of protective archaeology, protective cover, so that the remains can be recorded and then the development can continue. This is all commonplace, and it happens in urban development, of course, as everybody knows, as well as in rural development. So I'm struggling a wee bit to see what's objectionable about it. On the other hand, is it not de minimis simply to cover the access track? Is it not the applicant trying to get away with something which will be no effort at all, rather than considering archaeology across the piece?
You want to make any further comments, Mr. Bell?
Yes, so I think when we started the discussion this morning, I made the point that in terms of the circular, it makes it clear that there's need to avoid imposing conditions through anxiety to guard against every possible contingency. And also it says, as a matter of policy, a condition ought not to be imposed unless there is a definite need for it. And the EI assessment has been very thorough and detailed and has identified the area in which it would be appropriate to take that safeguard. And that would be on this particular area of interest, because again, it's a balance between getting on with the development and being proportionate in terms of the conditional safeguards that are put in place. And I think the condition as drafted does strike the right balance in that regard and is based on an evidential basis for it.
Thank you. If there's no more comments on archaeology, then we can come on to condition 34, which is forestry. Any comments on that? And then we come on to noise.
Sorry, Mr. Hall.
Yes.
Could I just comment on forestry, just to say that although it's agreed with Forestry and Land Scotland, there's actually been no plans that have been drawn up. So the total felling area for construction has not been presented, nor has any commitment or plans for compensatory planting. So surely these plans need to be made visible to all before any construction can go ahead.
I think that may be what the condition says,
yeah.
But I'll just ask Mr. Bell to confirm that.
Yes, I think these details would all be set out in that scheme to be provided.
Thank you. So noise, I wonder if it's best to deal with the suite of noise conditions altogether. And start with the council and the council's difficulties with the noise conditions as proposed. Is this one for you, Mr. Campbell, or Mr. Edgar?
So we're starting with 35, are we?
Well, if you can, well, I mean, if people don't think that's the easiest way of dealing with it, then say so. But I was going to propose looking at all the noise conditions, which is 35, 36, 35 and 36 together, just because there might be some overlap.
Okay. Well, the advice provided to us is that the proposed opening paragraph is as set out in the right-hand column, and the proposed paragraph C is as also set out in the right-hand column. Obviously, the council didn't take part in the noise session and has consulted its noise consultant when required. I don't think I can say any more just now until I see what is thought to be objectionable about those about those proposed changes.
Right. Very well then. Well, let's turn to the applicant and find out if they're content with these proposed changes from the council.
Colin, yes, no, we prefer the precision that the applicants have produced. It's standard condition, and we prefer the clarity with which it is expressed. We don't see the need to change it in any way as suggested by the council, first of all in relation to the opening, nor in relation to subparagraph C. And in relation to subparagraph C, the main difference between us is the inclusion of the word or component of amplitude modulation. Paragraph, there is a process within ETSU for dealing with matters relating to a tonal component of any wind farm noise, and should that be prevalent in relation to the the particular noise, it will attract a penalty, which then gets taken into account as to whether there is then overall compliance with the condition limit. And that is all provided for within the condition. What is not provided for within the condition is amplitude modulation, which is a particular characteristic of turbines, which is believed to relate to blade stall and the noise that derives from that particular characteristic of a very limited number of turbines. And effectively, there is not current agreement as to how there should be a penalty applied, or that is dealt with in a condition. And in our submission, in the absence of that particular level of agreement, that the incorporation of the wording relating to amplitude modulation in terms of this condition is not appropriate because it has no purpose, it is not required, and adds nothing to the assistance of what the condition controls or should deal with. Insofar as the current position is in Scotland, as a general practice, there has not been amplitude modulation conditions imposed, and that derives from the fact that there is a lack of consensus amongst professionals involved as to how that should be measured and applied in terms of any potential penalty. That does not mean that the amplitude modulation is as itself does not lack control. There have been a number of instances in Scotland relating to particular turbines where courts have found that the amplitude modulation in the circumstances has resulted in a nuisance. But in my submission, so there's two key factors to feed into this. One is it is a very rare occurrence that turbines suffer from amplitude modulation of the character which causes a nuisance. And secondly, because there is no accepted basis on which it can be controlled by way of condition, it's inappropriate to do so. And there is, as I say, an alternative mechanism that is used where such turbines cause amplitude modulation of a nature and character which results in nuisance.
So that alternative procedure would be the complaints procedure?
No.
Yes,
So what do you mean?
Yes, indeed. And Mr. Campbell knows probably all too well the fact that certain turbines have been found to not behave as predicted. And as a consequence, they have on occasion been taken to court through the nuisance provisions.
Mr. Campbell, does that give you anything to get your teeth into?
How long have you got? Yes, sir.
Well, I don't want to go through the sort of
no, I know.
noise evidence.
There's quite a lot of contentious material in that submission. So just try and take it in an orderly fashion. First of all, we're discussing a draft condition. So it's drafted in its last two lines with the words, the complaint contains or is likely to contain a tonal component. Sorry, read it again. The noise giving rise to the complaint contains or is likely to contain a tonal component or component of amplitude modulation. I think on reflection, the words is likely to contain could be deleted because they lack precision. Now, that's the first point. The second point is the statutory nuisance mechanism, which is to be found in the Environmental Protection Act 1990, section 72 onwards, depends on either the local authority being satisfied that there is a noise nuisance and taking enforcement proceedings by way of an abatement notice, which can be challenged in the Sheriff Court, or upon an individual doing the same thing at his or her own expense and using the Sheriff Court in order to achieve a sort of declaration that there is a statutory nuisance, and the Sheriff issuing an abatement notice. So it isn't a straightforward process. Experience tells us that although it's called a summary application in the court, it's anything but summary. There has been one such case in Scotland, and it took 2 years to get to court and was hotly contested. Now, whether or not amplitude modulation is a rare occurrence, and as Mr. Innes says, the provision has no purpose and is not required. None of us can say that in relation to this development, because we won't know until the development is erected. So this is a prophylactic measure which enables our council to act expeditiously if it is demonstrated that the noise contains either a tonal component or a component of AM. Thirdly, whilst it is true that the occurrence and the definition of AM is somewhat controversial in the acoustic community, the Institute of Acoustics Good Practice Guide provides a method whereby a condition can be a condition can be devised which will provide a route, an avenue for complaint if AM occurs. And so that you understand what we're talking about a shift in volume between the peak and the trough of every blade switch. So it's microscopic in duration, but nevertheless, it enhances. What happens when there is amplitude modulation is that the amplitude, that's the volume, modulates. It changes as the blade passes the tower, making the noise not a single event, but actually, when analyzed, an event which is best described as being on a scale. It's the difference between the peak and the trough which dictates the level which such a phenomenon can create, and therefore the level of annoyance which can be created. And as you'll understand from this rather bad layman's explanation, it's something that requires technical assessment. So if we go back to the condition, what we have is a proposal in paragraph C for expeditious management of any component of the noise which is disturbing at a noise-sensitive residence. What the condition requires is for the applicant to use a consultant, to be approved by the local authority, to assess the level of noise, and only to have to do so if there is a reasonable history of complaint, given date, time, and location, and so forth. Because the wind changes all the time, these events are very hard to capture, particularly to a layman, unless, like Mr. Shaw, you have the equipment in your house or on your patio or garden to enable you to do that. Mr. Shaw, who's an engineer, might be able to say, well, this is an AM phenomenon. Ms. Kendall or anybody else who's not an engineer might not be able to. All they might be able to say is it's just a nuisance, it is upsetting me. Now, lastly, I'm sorry to talk so long. Where is the harm, going back to Mr. Bell's caution that we note about what we put in conditions, where is the harm in inserting in a condition a possibility of the occurrence of what is a known phenomenon from turbines? We don't know that a 200-meter turbine will behave like this. What the Institute of Acoustics tells us is that turbines in line are more prone to this phenomenon, to delivering this phenomenon, than turbines which are differently arranged. But I don't want to give expert evidence. I'm certainly not an expert of any kind. What I can tell you is that the complaints about AM, whilst not numerous, whilst not very numerous, occur all over Britain. They give rise to widespread complaints to local authorities. Local authorities generally are not well resourced to deal with them, and that expert evidence is required in order to establish whether or not AM is present in or to a sufficient degree that it could be called disturbing. I'm trying not to use the word nuisance because it has a technical meaning. You'll see that the predicate for this subparagraph is a complaint from the occupant of a dwelling house. Sorry, it says the occupant of a dwelling, alleging noise disturbance at that dwelling. If you wanted to, you could use this condition to define the noise sensitive properties, since we're dealing in this case with a relatively small number of properties. I put in, instead of dwelling, you could put noise sensitive reception and then define them somewhere else. In concluding, my submission is ETSU does deal with tonal noise. It also deals with amplitude modulation. This is a precautionary condition which, if the applicants are confident about their product, will not and should not occur. Perhaps there's one other thing. To mitigate or ameliorate AM where it occurs will necessarily involve a reduction in rotation speed of the culprit turbine or turbines. Any reduction in rotation speed means a reduction in generation. Any reduction in generation means a loss of revenue from the project. At its most extreme, if the problem can't be solved, the turbine will have to be taken down. And that's never happened across Britain, because means have been found to slow the rotation speed so that the noise is reduced to an acceptable level. But we are talking, in dealing with AM, about the possibility of significant reductions in revenue, ultimately, for a generator. And that's why, let's be realistic, that's why the matter is so hard fought, because naturally the applicants wish to see a return on their investment at the best possible level. Sorry about that rather lengthy explanation, but I hope that's some help.
Mr. Innes, I imagine you'll want to come back on some of that, will you?
I wonder whether it's worth hearing from others and I come back as a whole at the end.
That's a more efficient way of dealing with it. I'll go to Mr. Grosvenor then, please.
Yes, perhaps Mr. Innes didn't follow the evidence that was provided in cross-examination with Craven, and certainly to start from the premise that certain turbines have not performed as predicted tells a whole story in itself, and I won't go there, but we fully support the position as laid out by the council. That's an acceptable position. And of course, what we have here, as Mr. Campbell has pointed out, is that we've got exceptionally large turbines. We just don't know how these turbines are going to perform, but we certainly have a good indication of the Hunterston situation. We would support the council's position on this. It's an acceptable condition. It's appropriate. It's manageable. Meets all the conditions for it. But in addition, what we're proposing, and again, we take exception to the comment this morning where there was late evidence or documents submitted at the last minute. The document that was submitted this morning draws together the request for the conditions that were in Mrs. Crosswaite's evidence, recognition referred to, and also Joy Kendall. So this is not new. It's not new before inquiry as of this morning. The most important point here is that given the experience that we have, and I can talk from personal experience of ongoing noise complaints regarding AM over many, many years, certainly in England, yes, it's a contentious issue. And the problem here we've got is that the wind industry are basically saying, well, you know, let's deal with it on complaints. Well, the complaint procedure, as in the case of Pat Spence, is long drawn out. It's costly. It's stressful. It leaves the residents in limbo for years. There are court cases that have been challenged and failed. This is not a way to go forward. Unfortunately, it's not good enough, as we said in our evidence, for a whole set of you know, conditions just to rely on, well, perhaps a resident should be complaining. You know, yes, if there's going to be a complaint, there needs to be a proper set up system to deal with those complaints. And the council have put forward a condition there which is acceptable, but the caveat we've added in is that, you know, that the local residents have no control over the complaints procedure. They're left caught between a rock and a hard place, between the council's position and the applicant's or the operator's position, and they're the ones that pick up the pieces at the end and suffer all the way through. So we would put forward, I know it's unusual, but given the circumstances that we're in, given the fact that we've got turbines of unprecedented size, unprecedented blade length, we would argue that there is a high likelihood of AM in this location, with the long blades, particularly with the stubby towers, which was also brought out in evidence in cross-examination. The applicant's position in this case is untenable and it's unsatisfactory. That's where we are.
Thank you, Mr. Grosvenor. Mrs. Spence.
I was rather curtailed yesterday on the end of the noise inquiry, and the point that I was about to make at that, and it is very relevant here, is that the applicant, by their methodology, are effectively stopping the council, that's South Ayrshire Council, from properly investigating what I am complaining about, because my main complaint has been about the low frequency noise. Okay, the turbines are quite noisy here, but obviously other people have experienced noisier, audibly noisier circumstances than myself. But my complaint has been about low frequency, and when the monitoring equipment was put into my house and left there for 12 months on the pretense, and I do say pretense, that they were supposed to be investigating low frequency noise, which they weren't, because as I said yesterday, the man Jiggins, who was doing the monitoring, kept me referring to perfectly audible sounds which seemed to be interfering with his methodology or whatever. And of course, during several conversations, I ascertained that it was not possible for his equipment to be investigating what he was supposed to be investigating, which was low frequency noise. So that they had the equipment in my house for 12 months under false pretenses. My complaint really comes down to a nuisance complaint. Now, the applicant persuaded South Ayrshire Council on a meeting December the 17th during this middle of this period, and the applicant, along with Hawley, who were doing monitoring, persuaded the council that, oh no, we don't have to account for low frequency noise, so therefore you don't have a problem. But I have a problem, and South Ayrshire Council still have a problem, because that is what is clearly causing my problem, as the P-harm evidence has shown.
So would your suggestion be that, I mean, where this condition, or the council's proposed condition, refers to tonal components and amplitude modulation, that it should also refer to low frequency noise? Would that, I mean, obviously you're dissatisfied with the noise situation in many ways, but in terms of the condition or possible condition, would that?
Well, yeah, I'm coming to that. Sorry for taking so long. The condition that I am advocating is, first of all, the applicant stops trying to influence what the council are investigating, and basically they persuaded the local council that I have no grounds for a complaint because they don't want to account for low frequency. Basically, that was what the meeting covered. And what I do have is a complaint for nuisance. And my complaint is that this low frequency noise is interfering with my whole livelihood, the way I run my business, the things that I am unable to do in my own property. And they think that they can tread roughshod over my entire life without having any responsibility for it or liability. And there is a law of
if I could try and bring you back to the conditions.
And they don't have any conditions to cover that, and they are trying to influence everybody else against ever highlighting the problem that I'm suffering with. And I'm not the only person, but I mean, I know very few people who are suffering this, but I mean, I know that worldwide there are quite a lot of people, and I would like them to be accountable for this, and surely some conditions should be put into effect. I should not have to spend all my spare money suing them, and I can't afford to sue them because you know, I have a house that's worth nothing that I can't sell. Effectively, I have no finance, because my house is worth nothing. And that is caused by the applicant. So there must be some recourse at some point.
Yes, I'm trying to establish what that recourse might be. And could it be a condition that said, for instance, if there is a complaint regarding low frequency noise from a defined set of residents, then the applicant is required to carry out an independent investigation or fund an independent investigation of that, for instance? Would that be a suitable condition?
Yes, provided it was a fully independent investigation, I would agree with that.
Okay, thank you, Mr. Spence. I don't know if there's any, I mean, I want to limit ourselves to the wording of conditions today.
Yeah, I do appreciate that. But I mean, I'm in this situation. What the hell do I do about it?
Okay,
I
understand.
see the applicant making any efforts to do anything about my situation, which they have caused. And it has cost me years of anguish.
Mm-hmm. Yes, I think.
Where do I go?
Really,
where do I go? What do I do?
Well, I think this is the appropriate forum to talk about what conditions could be applied to this permission, this consent, if it goes ahead.
Yeah.
To
Yes,
address that. I think we've identified a possible approach that we could follow.
Yeah.
Mr. Grosvenor, you had your hand up again.
Yes, I agree. I would support that inclusion, most definitely. I didn't touch it on it in my first part because I wanted to sort of move on a bit and see where we went with this, but certainly I would do. I welcome that suggestion on behalf of our residents.
Thank you, Mr. Shaw. I'm not hearing you, Mr. Shaw. You're either on mute or...
Sorry about that. I'm not sure what the answer is, but whatever condition you decide upon must encompass every kind of noise nuisance or potential noise nuisance from these turbines. I don't want to prolong this discussion. I'm only saying I think the same thing as everybody else. It's not good enough to concentrate on one element, because at the end of the day, I see this exercise as a huge experiment, and nobody really knows what's going to happen on the noise front on these turbines.
Thank you. Any other comments before I go back to Mr. Innes?
Just for your notes, XUR 97, which is before the inquiry, but I don't know its number, deals with what it calls blade swish at page 68. Just for your notes, you don't need to turn it up, but do remember when you're reading it that it was written in 1997. And it acknowledges the lack of scientific conclusions at that time. It talks about the current level of knowledge. Well, we're better informed now, and that's why the IOA, Institute of Acoustics, has produced its good practice guide for the benefit of both wind farm developers and wind farm noise receptors. Whether it works or not is not for me to say, but that's the sort of history of the matter. Page 68 deals with AM as far as it deals with it. Page 69 goes on to deal with tonal assessment and the production of tonal noise from two or more turbines harmonizing.
Thank you.
Thank
Mr.
you.
Innes.
Thank you, sir. In terms of response, I can be relatively brief. In terms of meeting the tests, in terms of a condition, there has to be sufficient precision and certainty relating to what has been sought in terms of the control being provided. In terms of the subparagraph C, which is proposed by the council, which adds on the words, or is likely to contain a tonal component or components of amplitude modulation. Just to put this in context, is subparagraph C is going through the process in terms of the operational noise condition, and it's dealing with the circumstances in which a complaint has been raised. What it's giving an indication to is a range of information to the operator about the nature and character of that complaint. And the key purpose and function for that last sentence, or the last part of the sentence in paragraph C, is a judgment as to whether or not, in terms of the applicant's drafting, or not the noise in question also contains a tonal component. The reason for incorporating those particular aspects is that if the council in paragraph C indicates that there is a tonal component to the noise, then subsequently in carrying out the assessment under subparagraph D, it is assumed that the process would involve the operator, as well as carrying out an assessment of the noise, would also be carrying out an assessment of the tonal elements of the noise, which is a separate and distinct element of the assessment process in terms of compliance, so that they would also be seeking to characterize, if they can, any tonal element within the noise that's being produced by the turbines. And within the condition itself, it goes on to provide guidance note 3, which provides a mechanism for effectively applying a penalty to the noise in circumstances where the character of the noise includes tonal components which meet the requisite characteristics of effectively contained within guidance note 3. And you'll see there that a penalty ranging from 2 to 5 dB is applicable depending on the nature of the tones that may have been found in the context of that compliance assessment. So that's the point about why in paragraph C, at the end of that condition, there is a reference to that particular aspect, because the tonal aspect of the noise is covered by the subsequent condition in terms of the detail of how it's dealt with and also the consequences for finding and whether or not it impacts upon compliance with the noise conditions that have noise levels that have been specified within the condition. And as the rider adding on or component of amplitude modulation, in my submission, cannot be appropriate because it does not have anything to catch up with or specify what the consequence is of that statement. As Mr. Campbell has eloquently set out, amplitude modulation occurs in respect of all turbines, in respect of their operation. So what we're dealing with here is not amplitude modulation, because all turbines have an amplitude modulation between the high and the low. The issue is excessive amplitude modulation, which in itself has the characteristic of the noise to be different. So the add-on of amplitude modulation does not add anything to the matter. It's because it's all wind turbines will suffer or have a component of amplitude modulation in relation to the noise that's produced by them. So in essence, what we're supposed to somehow read in here is excessive amplitude modulation, which is causing a problem. But the problem for the condition is there's nothing thereafter which goes on to provide any mechanism for considering that particular character, excessive amplitude modulation, in terms of characterizing what is or is not acceptable, or what consequence there may be if one were to treat it like a tone and apply a penalty to it. It therefore brings nothing to the condition, and in my submission, it could not be incorporated because it is unnecessary and lacks precision. And in effect, if you want to have an AM condition, you have to produce an AM condition, and you have to seek to define it. And that is the problem that it currently exists, is there is no consensus as to what that looks like, and there is no consensus how that is formulated. And in the circumstances, it's not appropriate to impose a condition that does not have the benefit of being precise and being necessary in terms of that. And I do stress, sir, that in the context of this particular aspect, it is not that common in Scotland for there to be excess amplitude modulation issues. There have been very few and far between, and that's illustrated by the number of enforcement actions that have been taken. As Mr. Campbell identifies, there's been one. And in my submission, that's an important matter in terms of dealing with this particular matter because it is on the extreme end, and that is why we have the Environmental Protection Act and nuisance provisions, is that they actually can deal with this type of matter far better than a condition. And if I can perhaps just explain, when Mr. Campbell dealt with his case, having read the reports, what appeared to be is that a number of expert witnesses went out to the particular locations and were able to witness the operation of the wind farms, and they were able to thereafter report back in their professional judgment the nature and character of the noise the turbines were producing. And ultimately the sheriff was able to determine in that particular instance that he, based on the evidence of the expert witnesses, was satisfied that a nuisance existed. But the witnesses did not define a threshold. It was based on their professional judgment, having gone and listened to the particular noise in question and the character that it had. And so one of the challenges, therefore, is that in formulating a condition, you cannot leave the discharge of a condition open to varying professional judgment, because in essence, that cannot be complied with. What we are testing through these compliance protocols is effectively, have we complied with the obligations that have been set out in the conditions? Those obligations are very specific, they're specified, you pass, you fail. It's not left to the whim of an individual to say you passed or failed. You pass or fail on the measurements that are undertaken, and therefore you have a clear mechanism for the enforcement of a condition. A condition cannot be left to the interpretation of an individual. And that's where this whole AM issue, excessive AM issue, until there is a consensus on measurement, how it's to be dealt with, becomes an insurmountable position relative to producing a lawful condition in the current context. And it is important that any condition has to be lawful, and then therefore needs to be a sufficient definition and specification so that the operator knows what they have to comply with. And in my submission, that's simply lacking. And you can't just say there should be a noise condition covering these matters and low frequency noise unless you've got an absolute definition of what it is that you're controlling. And that's the problem with excessive AM. And that's, until that's resolved, there is no lawful basis in which such a condition can be imposed. And that may be unsatisfactory in some respects, but there is a backup mechanism, and that is a form of nuisance. And that does provide a separate basis, which is informed by a separate professional judgment. And it is less hidebound by having to provide a specification of what you have to comply with up front, which is effectively what a planning or a Section 36 condition has to do. It has to tell you up front what you're going to comply with, or otherwise it becomes non-compliant with the legal requirements and the policy requirements in relation of a planning condition.
Thank you, Mr. Innes. Mr. Shaw.
Very quickly, sir. The construction of this wind farm has the potential to make my house unoccupiable, just as Miss Spence feels that hers is. If a condition cannot be drafted which will adequately cater for that potential, then with great respect, this application should be refused.
Thank you. Any further comments on this aspect?
So there's a lot in this. There's a lot in the topic, and my learned friend Mr. Innes has expressed the contrary view, if I may say so, very well and very clearly. I would like to respectfully suggest that this is a matter that should be dealt with in closing submissions, not at huge length, but Mr. Innes has raised 4 or 5 points, which would certainly take 20 minutes to half an hour to respond to, rather than take that time up today and do it on the hoof. It would seem to me to be better for you if it was down in writing, because it's not an easy topic, and nobody finds it an easy topic, not acousticians, never mind sheriffs or reporters or lawyers. It's not an easy topic, and it requires a bit of a wet towel around the head to think about just how AM should be analysed. So I'd like to suggest that, having heard and taken a note of what my learned friend has said, that you now move on from this, and, if I may say so, and allow it to be dealt with in closing submissions.
Yes, I appreciate the headline arguments now, but it certainly would be helpful for me to have things in writing as well. Mr. Grosvenor.
Yeah, yes, I would support that position. We will be putting in our closing submissions anyway, so we can address this issue as well. But again, we bring back the fact that the failure in the conditions at the moment exclude the most interested party, the victim. So that needs to be considered as well. Thank you.
Thank you. Are there any other matters to deal with quickly on noise? Any other noise matter before we break for lunch?
I think so.
Well, I had hoped that we'd get through all the conditions before lunch, but we haven't. I don't think we've got too much. Hopefully, not too much further to go. But I think we had an early start, so I think we do need a break. So I propose we break for lunch now and come back at 2 o'clock, and then we'll finish off conditions, and then move on to the other matters for the day. So we'll break till 2 o'clock, please. Thank you. Good afternoon then, everybody. That's 2 o'clock, so we can start again. I think we've got as far as condition 37. Just checking, seems to be people with us, that's good. And this is shadow flicker, where the council is proposing some additions to the condition on shadow flicker. Mr. Bell, are those acceptable to you?
No, sir. Our preference is to stick to the standard ECU wording for the condition. The reasons for that, the difference with the council's condition seems to be that the mechanism is based on a complaint, and that the investigation will simply then deal with the incidence of the complaint location. Now, the condition that we've proposed is precise in that it relates to shadow flicker occurring within 10 rotor diameters. And that distance is important because the Scottish Government advice on this matter, and that's in CD 4.3, which is the national advice on wind energy development, sets out that shadow flicker is not a problem where the separation is provided between the turbines and a dwelling within 10 rotor diameter of that threshold. And the EIA assessment has been undertaken in chapter 14 of the EIA report, and it's identified one property just within the threshold. We can come on to what it says about that, but the condition seeks to deal with the matter in terms of that scope. And again, I would go back to the circular, paragraph 15, where it says, if a condition has scope wider than necessary to achieve the desired objective, it will fail the test of need. So the condition as drafted is specifically formulated to have proportionate scope, and that is what is proposed. It provides adequate protection rather than the open-ended approach set out in the council's expression of it.
Mr. Campbell.
Thank you, sir. If you would look at CD 4.3, which inconveniently doesn't have numbered pages, but is electronic page 6.
CD 4.3.
CD 4.3. If you find the first bullet point on the left under the heading or the subheading impact on communities.
Sorry, I'm just getting that now. What page was it again?
Electronic page 6. It's an online online advice page, so it doesn't have any internal numbering for some reason.
The first bullet point, shadow flicker.
Yeah, the first bullet point, as you say, is shadow flicker, and it explains that at certain times of day and time of year, the sun may pass behind the rotor and cast a shadow. When the blades rotate, the shadow flicks on and off. The effect is known as shadow flicker. It occurs only within buildings where the flicker appears through a narrow window opening. Now, there are two phenomena associated with this. One is the one described here, which is where a stroboscopic effect can occur when the blade is between the sun and the building with a narrow window. And if you can picture yourself inside looking at that window, you can see the stroboscopic effect as the blade passes each time. But in addition, outside the house, in the garden, within a distance, whatever the distance is, wherever the sun is, there is passing shadow. And this is often called shadow flicker as well. The purists would say that's not true shadow flicker, it's just shadows. And it's true that it doesn't create the same stroboscopic effect. Nevertheless, it's widely reported that the passing shadow from the phenomenon of the sun being, of the turbine blade being between the observer and the sun is deeply annoying, or can be deeply annoying. The authors go on to say that developers should provide calculations, and that's easy to do because we always know where the sun's going to be. And they say, as a general rule, 10 rotor diameters is an acceptable separation distance. However, this document was written in 2014, 7 years ago, and of course we're dealing now with turbines of unprecedented size. I think from memory 75-meter blades. So I have to ask the question, and Mr. Bell may be able to help us. Does he contend that this guidance still holds good because of A, these two forms of flicker, and B, the change in the configurations of wind turbines in the last 7 years?
So what are the key points that you wish to capture in the condition that aren't captured now?
I'd like the applicant to do a calculation to show us when the shadow from the blades is likely to pass over an affected property over the calendar year. The phenomenon which is described here, the stroboscopic phenomenon, is relatively rare because a narrow window, it can last only 10 minutes as the sun moves around. But the phenomenon with a blade, passing blade phenomenon, is likely to be of much longer duration. What would I like to capture in the condition? I would like to avoid the possibility of the applicants building a turbine which is likely to create this effect on any sensitive residential property. So we have reduced a draft condition, which is in the right-hand column, which requires investigation upon complaint, but not unless there is a complaint. Now, you may ask me, well, what sort of complaint could there be? Since we know where the sun is going to be at any time, it's perfectly possible to envisage a situation where turbines are switched off for the duration of the phenomenon, which on any view will be a short time.
Yes, sir, thank you. The condition needs to be precise. That's why it deals with shadow flicker, specifically in relation to the rotor diameter distance. Mr. Campbell's rightly flagged that there is an effect called shadow cast. I've experienced that, and I've dealt with that in evidence on various inquiries throughout the UK. It's a very different matter from shadow flicker. This condition deals with shadow flicker, and the specific assessment for the development has been done, set out in Chapter 14 of the EIA report, specifically paragraph 80, which refers to the one property that falls just within the 10 rotor diameter distance. That's the property known as Ferter, at a distance of 1.48 kilometres from turbine 6. Now, the phenomena occurs when there is sufficient sunlight, so it wouldn't occur on a cloudy day. There needs to be a clear line of sight to an aperture of the right size at the right aspect, going into a room in which somebody is in to experience the effect. And clearly the assessment doesn't take account of any mitigation factors such as blinds in the room or whether there is any obstructing vegetation between that line of sight. Now, the calculation in the EIA assessment predicts 4.3 hours per year. Theoretically, such an effect could occur. So it's not a significant effect, and it's really a non-issue. It's a worst case situation that has been examined. And the condition does provide, nevertheless, for protection by way of a complaints procedure, should there be such an effect. Therefore, it can be dealt with in an appropriate way. So it's been properly assessed for this specific development, and the condition is standard and it is one that we think should be applied for the protection of that immunity effect.
So I quite agree that the distinction between shadow flicker and shadow cast or shadow throw is a proper one to make. And I also agree that this condition, as it is drafted by the applicants, is apt to deal with shadow flicker, subject to my remarks about the 10 rotor diameters and the size of the blades. However, Mr. Bell, in his response, has not dealt with shadow cast and shadow throw and the possibility of it. If, in truth, only one residence is possibly affected, then this should be a very simple matter for the applicants to put beyond doubt. And the condition, if there's no risk of shadow cast, then there need not be a condition, but the applicants need to demonstrate that.
Mr. Bell, do you want to come back on that again?
Yes, I would just say that I've dealt with that matter at various inquiries in inquiry procedure, and the issue of shadow throw or shadow cast has principally, in my experience, been raised by equestrian users who had an apprehension about the potential for the skiography, the shadow cast, to affect equine interests. And even the British Horse Society guidance, I think, identifies that that is not an issue, and there's been no evidence of any issue of injury or horses being spooked by shadow cast. And I've certainly not experienced it in terms of general human immunity as an effect being raised before.
Thank you.
I don't want to add anything. I don't want to add anything else. I think my point is perfectly clear.
Yes, thank you, Mr. Campbell. You had one point to make about the emergency contact number, which we've perhaps covered, but do you have any other comments on this condition?
Sorry, you're talking to me, sir?
No, Mr. Shaw.
Oh, Mr. Shaw, sorry.
Yes, sir, I have the point about the emergency contact number, but I also have the broader point that 10 rotor diameters is complete garbage. It was a rule of thumb which was invented in Spain something like 20 years ago, when the conditions and the size of the turbines was completely different. If you look at the diagram, mind that the applicant has created, the reason they argue that shadow flicker will affect us on 4 days per year is simply because that diagram cuts off exactly 10 rotor diameters, which is a few meters, perhaps 100 meters in one case, short of this house. Now, bearing in mind that these turbines are situated on ground which is very much higher than our property, it is my opinion that there is a strong chance of shadow flicker, not only in the evenings between March and September, but also quite often at this time of the year in the early morning, where it will affect us directly in our bedroom. So I would very much like to see the 10 rotor diameter argument removed from this condition. My point about the telephone is that this is a phenomenon which, when it occurs, which is extremely disturbing, and therefore we need an instant solution. We don't want to have to go through a complaints procedure. Once again, we're in the same position. If the applicant is right, and I'm talking complete rubbish, then we really don't have a problem. It's not an onerous condition for the applicant. If the applicant is wrong, it is potentially extremely difficult for us to deal with.
Thank you. Mr. Bell, do you want to respond to that?
Well, I'd just say hopefully to give Mr. Shaw some reassurance that there's been a detailed professional assessment undertaken by the relevant experts, and the condition is a standard one. And I think, hopefully the point I raised about that worst case situation, that it is a very small number, and there have to be a large number of variables in place before such an effect would occur. So it really is a very rare situation, and one that on the evidence is very unlikely to actually occur in this case. That can give some reassurance.
I'm sorry, Mr. Bell, I simply don't accept that.
Ms. Campbell.
Yeah, I'd also just like to come back at Mr. Bell and say the British Horse Society don't say there's no risk. There is a threat to some horses. and the equine industry about moving shadows, and that some horses do perceive them as a threat, more on hard surface than on vegetation, but they will be, that some horses are threatened by them. So it's not a no risk from the British Horse Society.
I think the point I was making was that it's referenced in their guidance, but there's no evidence at all of any injury to anybody in the UK from that shadow cast in relation to horse riding. In fact, many wind farms offer horse riding routes, and that happens, for example, in Whiteley and other Carlin Cross and other schemes around the UK where horse riding groups see it as a great asset. And clearly they'll be out on sunny days where there are some shadows being cast across the ground.
Good, thank you. We move on to condition 38, which is television reception. And again, I think the applicant is proposing the standard wording, and the council has some amendments. Perhaps Mr. Campbell, could you speak to the amendments that you're proposing?
Not sure if I can. Perhaps I must ask Mr. Edgar to help you on that matter.
Yeah, if I could just get a moment just to read this. I think we were really looking to insert words, any report done to investigate loss of TV reception is submitted to the complainant as well as the planning authority. I think that was the only.
Right, underlined, I see. Yes, I read it and I was looking for the difference, but Mr. Bell, any difficulty with that?
Well, I think there is, sir. The complainant may not want to be identified, and I think the planning authority is the regulator on the condition, and if there's agreement with the complainant to have information provided between planning authority and the complainant, that would be for them, and there would be provision for that to happen. When you examine the standard conditions on this matter, for example, for your note, document APP 6.3, which is the Galtaclay condition on Section 36 scheme, or CD 2.1 for South Kyle, or CD 6.13 for Falk Hill, that provision is not included. So that would be the reason why we would wish to stick to the standard condition wording, but it doesn't foreclose the opportunity for the complainant to be made aware of that information by way of the planning authority's communication with them in due course.
Thank you. Any other comments on that? Then we'll move on to 39, private water supplies. And here in the council column, it says to be confirmed. So, Mr. Campbell, can you tell me what your position is now on this condition? Or Mr. Edgar?
Well, perhaps I can begin. The council's position is that it is looking for an agreed method statement for sampling and monitoring private water supplies which take from the site. It's also looking for an agreement about preventive measures, or as they're called here, mitigation measures, to obviate any pollution or diminution of quality or quantity of the water supplies. Now, it may be said that this is a matter that can be covered by other conditions, which we looked at earlier. The applicant says there's no risk expected. The method statement will be provided to verify no impact to supplies. So there's no objection to providing the method statement. I'm not really sure that there's very much between us. Mr. MacLeod made some observations about this condition early on. I'm not sure whether he's seeking to consolidate this and the earlier condition, or whether he wants them to be separate. 19, I think it was. And he wanted the insertion of the words relevant published guidance and methodologies And for the reasons I gave earlier on, I resist that change. Miss Lobban, who was the council's witness, explained that she had reached her conclusions by walking over the site. Mr. Ritchie, who was the applicant's witness, explained that he has reached his conclusions principally by the consultation with published guidance and methodologies, but also by inspections. We contend there is no substitute for site inspections, and they have to be thorough and exhaustive and reported upon, which is what Ms. Lobban has done. So I don't really believe there's very much between us here, because all we're looking for is a method statement. And method statements for water sampling of PWSs are 10 a penny. They're quite easy to draw up and they're quite easy to find precedents for.
Thank you, Mr. McLeod. The condition refers to a method statement, so perhaps Mr. Campbell's correct. There's not too much between you, but do you have any comment to make?
No, that's correct, sir. The only addition is the one that I mentioned this morning, which is that we propose that the condition reads, there should be no commencement of development unless a method statement based on relevant published guidance and methodologies for sampling, etc. And then the condition continues. And to be clear, we're not precluding, or that wording would not preclude site visits from taking place. The point is site visits would take place and the calculations and method statement would be produced based on published relevant guidance, not based on some opaque concept of what might be appropriate or not.
Well, I'm quite resistant to that use of language, I'm sorry to say. There was nothing opaque about Ms. Lobban's evidence. She gave absolutely clear indication to the inquiry where she'd been and what conclusions she'd drawn. So it's all very well to denigrate her because she's not a professor of this or a professor of that, a mere environmental health officer, which I think is what you're trying to do. But she gave understandable, precise evidence about her walkover and the conclusions she'd drawn. And
that will be a matter of that will be a matter of submission in due course. And the reporter heard the evidence himself, and he will ultimately have to decide on whether Ms. Lobban's evidence was accurate or not. My point here is that we are looking for the condition to be precise and to make specific reference to the need for the statement to be produced based on published guidance and methodologies. If it's not to be produced on the basis of published guidance and methodologies, my question would be, what is it to be produced on the basis of?
Well, I'm not answering questions today.
No, thank you.
Although I could, I think you can see what the difference is between us, and really it's just the insertion of a few words in this condition. The arguments are the same as they were for condition 19.
Yes, they are. I'll take a view on that. Any other comments on this condition 39? Then condition 40 regarding redundant turbines. Mr. Brown, I think the airport again was seeking notification here.
Yes, sir, but in any event, this will now be covered by the revised condition 15.
Right.
As part of that exercise, sir.
That's right, yeah. Any other comments on condition 40?
No, sir.
Or from anybody else? And then 41 seems to be wholly consequent on my conclusions regarding condition 1 and the duration of the consent. But beyond that, there doesn't seem to be any dispute between the parties here. So any further comments here?
No, thank you.
And then 42 is around the financial guarantee. Any comments on that? And then finally, I think condition 43 on the planning monitoring officer. Mr. Innes, is it for the applicants who dispute the need for a planning monitoring officer?
Yes, sir. It's a function of the planning authority to exercise any powers under the condition that are applicable to them. In terms of the process, we don't believe this is a scale of a project that requires a PMO, and equally, in terms of the way in which the environmental ecological clerk of works is set out, they have a key role both in monitoring and reporting the key construction matters, and that clearly is is a duplicative function of a planning monitoring officer, in the sense of the terms and conditions are already being monitored and with a duty to report, and this is essentially duplicating that and is unnecessary.
Thank you, Mr. Thank you, Mr.
Mr. Edgar, I think this is one for him.
Mr. Edgar.
Yeah, thank you. It will always depend on the remit of the ECOW, whether that's an ecological remit or a wider environmental remit. The council's asked for this condition just to reflect resourcing issues that the council has in monitoring these large-scale developments, and the time that can consume of a very limited planning staff resource. And we ask you to consider it.
Thank you. Now, in terms of any further additional conditions that anyone seeks to be posed, I have a note, Mr. Shaw, for an additional proposal regarding property purchase. You want to explain that?
Yes, sir. The applicant has fielded, I think, 3 advocates this morning, whose purpose is to try and keep these conditions as to be as I don't know what the word for opposite of onerous is, but to try and keep these conditions as easy as possible for the applicant. My concern remains the same throughout, and that is that I still, despite all of the assurances, perceive a serious possibility that the construction of Clauchrie wind farm will render my house unable to be occupied. If that's the case, then I would like a mechanism whereby the applicant will purchase that property at full market value and I can walk away from it. It's bad enough to be driven from your house, but it's certainly unacceptable to be driven from your house. If I'm wrong and the applicant is right, then this will not be an onerous clause for the applicant. If I'm right, then I think I'm entitled to be protected by the applicant from the consequence of their actions.
Thank you. Mr. Innes, your response to this proposal?
Yeah, I mean, fundamentally, it doesn't meet the tests of the circular. It's not necessary, and actually it's wholly inappropriate. The issue about circumstances where people may be forced to buy properties is actually caught up in the Planning Acts. There are concepts of purchase notice and blank notice, and Parliament's dictated who and when such liabilities accrue to. It's not within the competence, in my submission, of a condition related to a planning commission to essentially introduce new law in such a fashion. I'm afraid it's simply just not competent, sir.
Thank you. Mrs. Spence.
I also suggested that this should be included in the conditions. I think in my original statement of case, and it would prevent people like me from being in the situation that I'm in. And I think that the danger of Mr. and Mrs. Shaw and Joy Kendall becoming involved in a similar situation is very high, given the size of these turbines and the closeness to them. I think if this wind farm is built, they will have exactly the same problem that I have. And without such protection, I've been ignored and forced to go on living in my property, given all these problems with the existing wind farms. And they know about these problems, and they are compounding the situation by proposing to put even bigger wind farms in place, which quite frankly, I think I just have to get a camper van and move out with the cats, because I would have to abandon my house. And Mr. Shaw, Joy Kendall, and lots of other people are likely to be in this situation. And why should we? We've worked all our lives. We've paid off our mortgages. We're perfectly independent people, doing no one any harm. And then suddenly you have forced us into this situation as the applicant, and you don't seem to give a damn. It's just money. And there are more things in life than money, but having none is not very pleasant. So I think that this condition should be applied as it would be to people when you're putting a road through somewhere and it's going right past your house. I think it should be a similar situation, and we should be treated in that way. I mean, also given the number of years that I have put up with this situation through lack of ability to do anything else, I think some sort of compensation should be paid for the disturbance and inconvenience. And please do something, because I am desperate.
Thank you. Ms. Clauchrie.
I would just like to say that we have a precedent here, in that we have these 100-meter turbines that are constructed to people's homes other than the Hunterston ones, where we saw that many people were actually driven from their homes. And also, if we go to a village called Bargrennan, Scottish Power Renewables actually paid to move a house and rebuild it so that they could get their turbines round the bridge. So I think that there are times when they will do this if it is to their advantage. And I think that this wind farm is so large and is so close to people's homes. 2 kilometres is standard, and look how close they are to Shallock and to Furta. And we have seen evidence in the proceedings about ILFN as well. And so I do think that we have a precedent here that a condition could be set like this.
Thank you. Any further comments on this proposal or any other further suggested conditions?
Yeah, I just want to point out, sir, that there is evidence in this inquiry of at least 2 homes that have been abandoned. Certainly one was abandoned without any redress, and certainly one was bought out due to the noise and shadow flicker impact at Hadyard Hill. So this isn't unusual, and of course the turbines at Hadyard Hill, to my knowledge, are certainly of a similar size to the turbines at Mark Hill. How it's dealt with is a moot point, but certainly it cannot be ignored. It certainly cannot be ignored. And the request for this condition, I believe, on behalf of the local resident, it's fair, it's appropriate, and it can be, it meets the test of enforcement as well.
Thank you. Any further comments on conditions?
Going, gone.
Well, thank you for that. And we'll move on now to some quick, not really closing remarks, because we've got our postscript about coming back to the radar mitigation matters. But I did say that I would deal with matters around the site inspection and closing submissions this afternoon. So we'll move on to that. So I'll deal with closing submissions first. So there is an opportunity for parties to make closing submissions in writing. These aren't compulsory. I do have all your evidence already, but they can be a useful way of summarising your case and particularly making points that arose out of the inquiry sessions themselves. But closing submissions must not be used to introduce any new evidence. The standard practice is for objectors to submit their closing submissions first and the applicant a few days later. In my notes last week, I floated deadlines of 2nd of July for objectors and the 9th of July for the applicant. However, I agree that given the length of this inquiry, a little tight, and also I am on annual leave until the 16th of July in any event. So I would now suggest that we go with deadlines of the 9th of July for objectors and the 16th of July for the applicant, but I'll take people's views on that. Mr. Innes, does that sound acceptable to you?
In broad terms, yes, sir. I was just thinking that in terms of we're submitting further noise material on the 2nd of July, our revised conditions on the 2nd of July. I was thinking that if other parties have to submit by the Friday, they'll probably have had less than 5 working days. And I was thinking possibly the Monday might be a fairer time slot for the first tranche of submissions, followed a week later by the applicants.
So that would take us to so that'd be Monday the 12th for objectors and Monday the 19th for the applicant. I'm certainly content with that. Mr. Campbell, what's the council's view?
The council's view and my view is that a better date would be Monday the 19th of July. From my point of view, that's because of other professional commitments. And from the council's view, it's because of absences on leave. I appreciate that's quite a long time, but I'm reassured by the fact that you'll be on holiday, so you won't be reading it anyway. It tends to be the case that a reasonable amount of time, a generous amount of time, leads to shorter submissions. So I can live with the 12th, but I would rather live with the 19th. That's my position. And obviously the applicants would be a week later, which would be the 26th.
And other parties? Ms. Jack?
I think, like Mr. Campbell, due to other commitments, my preference would be the 19th, but I'm in your hands in relation to that. I was just looking to check with Ms. because I wasn't entirely sure whether there were any holiday commitments that would cause any difficulties from her perspective. Perhaps Ms. Kinnis could just confirm the position there.
Yes, thank you, Ms. Jack. We'd be happy to go with the 19th for the submission of objector submissions, if that's not too long.
It is quite long, but as has been said, it is given the time of year with people being on leave. Perhaps we could consider it. Mr. Brown, does the airport have a view on this?
Yes, sir, thank you. I would adopt Mr. Campbell's suggested date of the 19th of July, and the reasons for that, sir, are twofold. First of all, when it comes to preparing the submissions, I would like to confirm those with the team, which has given evidence on behalf of the airport, and due to holiday commitments, the 19th of July is a realistic date for that, and also my other long-standing court commitments would make it easier for me to prepare submissions for the 19th as well, sir.
Well, very well then, we'll go with that. I won't get everyone's views because I'm not prepared to push it any further back. Or Mr. Innes, did you want to come back at all?
No, sir, I'm in your hands. I'm perfectly listening to other parties' commitments. It's almost better to have a better submission than if there are problems with availability. So we're happy to run with that, sir.
Very well then. So if we could have closing submissions by the 19th of July, then from all parties out from the applicant, and then the 26th of July from the applicant, please. And then the next matter was the site inspection. So my office has been in contact with Forestry and Land Scotland, who own the forest estate, and they have confirmed their permission in principle for the visit to take place. And we have now fixed the timing of that for the 30th of July, but now at 10 o'clock in the morning for the start, given the amount of ground to cover. I circulated my thinking on the itinerary last week or the week before. And first of all, I've got Mr. Shaw. Perhaps I'll come to you, Mr. Shaw. You've also submitted a document about the itinerary. I didn't recognise all the place names in your document, but is that broadly following the same route that I've identified here and I showed on the maps that I circulated yesterday?
Absolutely, sir. It exactly follows the route that that you showed. It's exactly.
Good. So, I mean, generally, are people content with that as a route? I think we can decide on the day if people want me to stop at particular points on that route to look at particular features of the site, then I'm happy to do that. So we didn't get too hung up on the actual individual stopping points at this stage. But does anybody else have any comment to make about the route? Good, because I need to finalise that with Forestry and Land Scotland. Now the meeting place, Mr. Shaw, you probably are the one here with the most local knowledge, and you say there is a suitable point for cars to park just a little bit up the forest road. Is that correct?
Yes, sir, that's correct. It's about 250 metres north along the forest road, having left the A714.
And there's no scope for confusion as to which forest road we'll be talking about. I can envisage us going up different forest roads. That's all.
It's one shown on your map. So it's the access road to Clauchrie Wind Farm, which commences at the chambered cairn adjacent to the A714.
Good. Now I shall be travelling in my own car, often in site inspections of this nature into off-road situations. We have a situation with joint transport where perhaps the applicant or the council provides an off-road vehicle. But because of the COVID situation, I don't think that's appropriate here. So I will be traveling in my own car, and I would recommend that other parties do the same. And the recommendation from various people is that four-wheel drive vehicles should be used, and I've requested to hire one of those for myself. And generally we'll be staying close to cars, but there will be some rough walking involved when we get up to the Cairn Hill area, potentially. So people will need to be suitably equipped for that. Now, in terms of the parties taking part, I had envisaged the applicant and the council joining me for the entire itinerary. If I could just confirm that's agreeable to the
Yes, sir. In terms of attendance, it's likely to be a representative of SPR, together with Mr. Craven, James Welsh, and Mr. Ritchie, and they would obviously engage insofar as any matters related to their particular matters in terms of pointing matters out. And obviously we don't quite know what's going to be pointed out, and that's why we potentially need those three parties present. So if it would be helpful if things are being stopped and pointed out, if we could understand the context before we start, because it then might drive who then actually stands in earshot to have that discussion or pointing things out, if that's okay. And the other matter we were just going to raise in relation to the site inspection is we did note that when Mr. Shaw put in comments on the itinerary, that he at various points said he was going to make submissions. There is a restriction really on the nature and extent of discussion that can be had at a site inspection, and it's not really to discuss evidence, but to point matters out that draw from that evidence, as opposed to having lengthy submissions on matters that might be called evidence. And I just want to make sure that we have a collective understanding of what is acceptable and not acceptable on that site inspection, to ensure that it's appropriate. And I appreciate there is that's an entire matter for you, sir, but equally there is a limit to how much we can actually have evidence on a site inspection. It is very much about pointing things out, as opposed to here's what I wish I'd said or given evidence of at the inquiry.
Yes, I was just going to come on to that, but you've saved me the trouble. That is the case, that this isn't an opportunity for new evidence. It's an opportunity to point out to me the physical characteristics of the site, and certainly with the aid of the visual information we already have in terms of visualizations and so on, and descriptions of private water supplies and so on, that are already before the inquiry. So I wouldn't be expecting any additional material to be produced or any additional evidence. It's a question of saying, this is what I was talking about in the course of my evidence last week. And for the council, Mr. Campbell.
Yes, so my council's officers understand the rules about site inspections. I think it's likely that Ms. Lobban and Mr. Edgar will accompany you.
Thank you. Now, it would be very helpful, well, necessary for me to, or for my office to receive details of the different cars that are going to be attending the site inspections. So if all parties who, certainly the ones who are intending to travel through the Forest Estate, could email Smera Akbar their registration numbers of the cars that will be involved in advance, and we can forward that to Forestry and Land Scotland. I've received various pieces of information from Forestry and Land Scotland around health and safety. I won't go through that now. I know Mr. Shaw also expresses his knowledge of health and safety requirements in the area. So we'll go through that on the day, just at the start point, I think. Any other comments? Yes, Mr. Shaw.
So could I just, when you've received the information about the cars, if you could perhaps just let me know approximately the number involved, then that will enable me to print the right number of copies of the safety briefing.
I don't know if it's necessary for you to produce the safety briefing. I mean, I will have received safety information from Forestry and Land Scotland, and you can certainly comment on that at the time, but I'm not sure it's within your remit necessarily to do that, but do you feel that's necessary?
If you've received information from Forestry and Land Scotland, then that was concerned in case that wasn't the case, that people should be advised about the relatively small risks of being within the working forest.
Yes, I mean we'll go through that, as I say, when we meet, and by all means, if you want to chip in with additional comments at that time, then that would be fine. But I don't think it's necessary to print off any sheets. Mrs. Spence.
This is getting to be rather an alarming number of cars, and I suspect that if you all came all the way along our road in your cars, you might find yourselves having to reverse all the way back, and that's roughly a mile. So I'm going to have to suggest that the cars are left at the junction with the sea road as you come out of Bar Hill, and you walk 0.8 of a mile to my property. Otherwise, it could become very chaotic.
Well, I wonder if everyone needs to come to your property because, for instance, private water supplies isn't an issue where you are.
Not for this one.
So I suspect it may just need to be myself, Mr. Edgar, perhaps Mr. Welsh might be the only people who need to come to your property, perhaps not, and perhaps a representative of SPR. So it may not be as many as we think. What do you think would be the maximum number of cars that could get to you?
Well, to get here and to be able to turn round, probably two. I mean, it could be first come, first parked, and some to walk in. Battle of the fittest or something like that.
Perhaps the reporter could pull rank and he could have one of the slots. That might not be appropriate. Well, that's noted. Then we'll. I mean, maybe it's a possibility for a short distance for people to share a car sitting in the back with the windows open for that short distance and to get a lift along that last little bit.
I'll leave you to come to an arrangement.
We'll come to an arrangement, but I've noted that maximum of 2 cars to come down your lane. Any other comments on the arrangements for the day? I mean, as I say, I'm not expecting everyone necessarily to join me for the entire visit. As long as there's somebody from the council and somebody from SPR there for the entire time, then people can join me just for the bits that they are interested in. Obviously, I can't be certain about, for instance, Mrs. Spence, you're at the end of the inspection, so I can't be certain about the time that we'll get to you. But perhaps you.
I'll be here all day probably anyway, so it won't matter.
Very well. Thank you. Well,
sorry, can I just check the date, please? I didn't know if it was 30th of June or 30th of July.
Sorry, 30th of June.
June. Thank you.
Yes. Next week. Well, I'll confirm those arrangements by email by the end of this week. Then I think just final words. Thank all the parties for their time and commitment to the inquiry process. I realise it can be quite daunting, especially for those not accompanied to this type of forum. But I think everyone has risen to the challenge very well and raised a lot of thought-provoking arguments for me to ponder over the coming months. I won't give any hostages to fortune as to the likely date of my report, as you won't be surprised to hear, but with annual leave commitments and other casework that I'm involved in, it's unlikely that I'll be sending my report to Scottish ministers for several months. Any final questions?
Sir, for the council, we're most grateful to you. Thank you very much.
Thank you, Mr. Campbell. Then thanks again for your participation, and I'll say goodbye there, and we'll have a short break now, and we'll come back to the resumed radar session at 3:05, please. Thank you.
Thank you very much.
Thank you.
Thank you.
Sir, it's Amy Cornelius from Denton's. Would you mind, I'm just in the GPA witness room, if I was just to quickly test the camera to make sure it works before Miss Kilpatrick's evidence?
Yes, go ahead.
Thank you. Okay. Thank you.
Right. While Ms. Kilpatrick is getting ready, we can probably make a start. So this is the resumption of our consideration of aviation matters, which we delayed in part to issue some questions to Mr. Geese. And I note that we've now received his response. Before we start with Ms. Kilpatrick, Mr. Brown, is there anything else we need to discuss first, or?
No, I don't think so, sir. Not at the moment.
And Mr. MacLeod, happy to proceed?
Yes, I am, sir. Nothing else from me at this stage.
Very good. Then, if your witness is ready, then Mr. Brown, if you'd like to introduce her, please.
Thank you, sir. Yes, sir. My next witness is Miss Zoe Kilpatrick, who's the commercial director at the airport. And sir, with a view to making progress, I don't propose to ask Miss Kilpatrick to read all of our recognition. I'll just ask her to read selected passages from it.
Very good.
Thank you. Miss Kilpatrick, could I ask you to have your recognition before you, please?
Yes.
And could I ask you, please, to read paragraphs 1 and 2?
Yep. Paragraph 1. My full name is Zoe Kilpatrick. My address is care of Glasgow Prestwick Airport, Prestwick, Ayrshire, KA9 2PL. Paragraph 2. I joined Glasgow Prestwick Airport, the airport, in 2018 as the commercial director.
Thank you. And could I take you to paragraph 14, because I understand you have an amendment you wish to make to that paragraph?
Yes, I would like to change a word on the third line of paragraph 14. It's the word controls. I used an informal and old-fashioned terminology there, and the word should, in fact, read provides services.
Thank you. And then could I ask you to turn to the next page of your recognition? And between paragraphs 18 and 19, you have a heading which is the cost and risk of providing mitigation. And could I ask you to read that heading to the end of your recognition, please?
Yep. The necessity for mitigation has obviously been caused by the developers who wish to erect wind farms rather than by decisions made by the airport. The airport, just like SPR, is a commercial organisation. As a commercial organisation, the airport cannot be expected to incur the expenditure and accept the risks which will be necessitated by the proposal without being remunerated by SPR. SPR will, after all, be making a profit for the proposal. It will be part of its commercial undertaking. Should SPR not be required to pay for the benefits being provided by the airport, it will be making a profit at the expense of the airport. Put that way, it is obvious that the burden of providing mitigation should not fall upon the airport. The principle of it falling upon the developer is accepted by SPR in paragraphs 95 and 100 of its Aviation Policy Inquiry Report. The issue is how that remuneration should be calculated. As I've explained, the airport is willing to invest in equipment and staff training, 24/7 monitoring of services, and upgrading of hardware and software for a minimum 25-year period. I have also referred to the fact that as part of providing the mitigation,
the airport is accepting the risks associated with always being able to provide that mitigation. It's clear from its published accounts that SPR generates substantial profits from its activities. For the years ending 31st of December 2018 and 2019, SPR reported a net profit of £150 million and £284 million respectively. Given SPR and the airport are commercial organisations, the amount to be charged should therefore be left to negotiation, as would be expected in any commercial environment. Part of SPR's objection, in brackets, paragraph 96C of its aviation policy inquiry report, close brackets, is that the airport does not offer an open and transparent reconciliation of the actual costs incurred and the charges for the same. The airport is obligated to provide services to its customers on a cost recovery basis. In the same way, SPR does not sell at a price that merely recovers the CapEx and OpEx associated with its generation. Further, SPR's approach fails to take into account the costs which the airport will incur in providing mitigation, and the fact that it is accepting the risk for a minimum of 25 years of being bound to provide mitigation, for which it should receive the return. SPR has made no meaningful attempt to engage with the airport to discuss the terms on which the airport should provide mitigation. SPR is clearly of the view that, in this instance, it should not have to pay anything to mitigate the adverse effects its development will have upon the airport, and that the airport should accept the potential of that in perpetuity. SPR appears to have reached that view, even though it recognises the principle that a developer should pay mitigation, and other developers with whom the airport has entered into mitigation agreements have obviously recognised that principle. Conclusion. For reasons which will be explained by others, the proposed development without mitigation will have an adverse effect on the airport's airspace. It is not appropriate that the airport should be left to accept both the cost and the risks associating with ameliorating that impact in order to safeguard its airspace. Mitigation is required as a direct result of the proposed development, a development from which SPR expects to yield a return. The burden of mitigation should therefore fully fall on SPR, which stands to make a profit. It's part of the cost of doing business.
Thank you, Ms. Kilpatrick. And are you content for the remainder of your recognition to be taken as read by the inquiry?
I am.
Thank you. Now, I've got some questions for you arising from your recognition and from the evidence before the inquiry. Starting with the second paragraph in your recognition, you described yourself as being the commercial director at the airport. What does that role involve?
Well, I'm responsible for all commercial areas at the airport. You know, and that ranges from our various aviation activities to fuel, from our car parks to our extensive property portfolio. I'm also responsible for business recruitment, and that includes things like spaceport.
Okay, thank you very much. Now, can I just point out that there are many people taking notes, Ms. Kilpatrick, so perhaps you could just take the evidence just a little bit more slowly to allow those making notes to keep up. Thank you. Now, Ms. Kilpatrick, you remember that in the course of Ms. Mackenzie's cross-examination, she referred to the dichotomy of views between the airport sector and the renewables sector, so far as the cost of mitigation is concerned. And at one stage in her cross-examination, I asked her to confirm her earlier evidence, and she said, so far as the dichotomy was concerned, and in response to that, she said, yes, and I think that was quite demonstrated by one of the documents you put in your, and then unfortunately we had a slight interruption to the webcast. But she then said aviation is good, renewables are bad. Now, what comment would you make on that statement? Aviation is good, renewables are bad, so far as the airport is concerned.
Well, certainly, I certainly haven't inferred at all that airports are good and aviation is bad. And just to be absolutely clear on that point, that is certainly not the position that the airport holds or has ever held. We understand the importance of renewables in achieving net zero targets, and we understand the importance of our role in helping to enable that generation of renewable energy. We certainly see ourselves as enablers rather than blockers.
Okay, thank you. And we've heard evidence about the number of operating wind farms in the vicinity of the airport at the moment and potentially the number in the pipeline. How does the airport feel about having wind farms within the vicinity of its operations?
Well, as you've already heard from Mr. Kirkland and you'll hear from Mr. Fido, wind farms, undoubtedly have an ongoing impact on our operations, and aviation safety is paramount to us. But the airport has been keen, from way back when, to find a way in which it can work and coexist with wind farm developments and enable the generation of renewable energy. And I think we've demonstrated that we've done that very successfully over the past few years.
Okay, so just in that vein, what steps has the airport taken towards working and coexisting with wind farm operators?
Well, the journey started, a long time ago, but certainly over the past 10 years, the airport has committed a significant amount of time and energy to get us to where we are today. We have a very well tested, robust safeguarding process, and we're also on the cusp of commissioning, a new suite of surveillance, which has the capability to mitigate wind farms. And actually, we should remember that Prestwick was one of the first, if not the first airport in the UK to go to tender on a full 360-degree wind farm tolerant radar. And since the system's acquisition, certainly over the past 4 years in particular, Mr. Thompson has spent, a huge amount of time working on the implementation and the testing, commissioning of the new surveillance system and building the safety case, which we anticipate will be approved in the not too distant future. Probably about 50% of Mr. Thompson's time over the past 4 years has been dedicated to that. He's had support in that endeavour from other colleagues at Glasgow Prestwick Airport, as well as help from third-party experts, including Mr. Fido. And in parallel to that, over the past 18 months, Mr. Thompson has also been quite heavily involved with probably about a dozen developers working on the safeguarding process for wind farms that are currently in the planning process.
And how does the airport engage with wind farm operators and other developers?
Well, from the outset, we really do try and seek to establish a collaborative and positive relationship. We very much encourage early engagement from the developers. As I said, Mr. Thompson has a very well tested, a very clear safeguarding process that he takes developers through. And in parallel to that, we discuss the mitigation agreement. We're engaging with developers with the mindset that we're trying to find a solution.
Okay, thank you. And when you're trying to find that solution, what policy issues arise for the airport?
Well, as you've already heard, and you'll hear from Mr. Fido, we have a lot of regulatory obligations. That's no surprise. So no surprise, we're an airport, and the ones that are of particular relevance here: CAP 764, CAP 670, CAP 760. I think we've heard references to all of those so far at the inquiry, and the CAA mandate within these that the responsibility for the provision of safe services and safe systems lies with the ATS, and that's the airport. So that's our responsibility.
Okay, thank you. And in her cross-examination, Ms. Mackenzie said that it was clear from your recognition that you think that if the applicant makes money out of generating electricity, the airport should also make a profit out of generating electricity as well. What would you say in response to that comment?
Well, I'm not entirely clear how Miss Mackenzie's reached that conclusion. In fact, I was trying to say something quite different there. You know, I did say that SPR, you know, make money out of the generation of electricity, and they do. But I also said that the result of the development, you know, has an impact on the airport, and that impact means that we are subject to additional cost and additional risk that endures throughout the lifetime of the wind farm. And we have no commercial interest in the wind farm development, and therefore it's not reasonable to expect that we absorb the costs of that. You know, this is not about GPA making a profit out of electricity. This is about GPA not being exposed to the costs and the risks that are imposed on it as a result of the development, whilst the developer makes a profit.
Now, you're absolutely there. You mentioned cost and risks on a couple of occasions, if I picked you up correctly. Now, so far as the first item is concerned, costs, at this stage, what are the headlines of cost you're talking about?
Well, there are initial costs, things that come right at the start of the process, and then there are costs that continue throughout the life cycle of the wind farm.
Okay, well, I'll come back to that with you in a moment. And so far as the second aspect of risk is concerned, again, at a high headline level, what risks are you referring to?
Well, there are risks that we're aware of now and we're cognizant of now, but clearly we're talking about a long-term commitment here, so there are risks that we aren't aware of at the moment.
In our cross-examination, Ms Mackenzie asserted that there are no risks for the airport. What would you say in response to that?
Well, I'd say there absolutely are risks, and I'm sure we'll come on to talk about those, but, you know, we certainly don't share that view.
Yes, well, I'll come back to you on that, Ms Mackenzie, but Miss Kilpatrick, but for the moment, I would like to talk to you about the role of wind farm mitigation agreements. What role do wind farm mitigation agreements play in resolving the tension between which can exist between the airport operators and renewable companies?
Well, I think the other airports and ANSPs who are watching this will agree with me that far from being the villain of the piece here, wind farm mitigation agreements actually are, a really important part of the solution that's enabled a significant amount of onshore wind energy to be generated to date. They are effectively mitigating, for want of a better word, the additional costs and risks that an airport takes on when it undertakes that commitment. And in return, the developer has certainty that allows them to continue its operations, to generate electricity, to generate profits for 25, 30 years, possibly in perpetuity.
All right, and when it comes to putting a mitigation agreement in place, you mentioned you're the commercial director. What role do you play in that process?
Well, I was involved in the development of the latest agreement, and I am involved in the negotiations of wind farm agreements with developers. I'm the principal person at the airport who provides instruction on those agreements, which are always subject to final board approval.
Okay, thank you. Now, I'd like to take you back to the question of costs, which you referred to earlier on. And when doing that, could I ask you to have before you the airport's safeguarding assessment process, which we've looked at before in the inquiry, and that is document reference GPA 22.
I have that.
Thank you. Now, looking at this safeguarding process, can you help the inquiry identify the costs which are incurred as this process is followed through, please?
Yes, well, there are costs that come pre-construction. So I'll point you to step 6, which is conduct baseline PD flight trial, and to step 8, which is conduct thermoradar modelling assessment. So those things both happen before the wind farm has been constructed, and the developer would pay for both of those stages of the assessment as they occur. And then following that, if I can direct you to step 14, which happens post-construction, radar optimised in airspace above visible turbines, and then step 15, undertake confirmed flight trial over wind farm radar optimisation. So they both are covered by the wind farm mitigation agreement. So there's no additional charge, is what I mean by that. That's included as part of the agreement.
And to whom is the airport making payment for these charges?
Well, in the main, the charges are with third parties here. So obviously, you know, we have to pay somebody to conduct a flight trial, and you know, most of the modelling work is done by NATS.
Yeah, and to what extent is the airport involved? Who else is involved on the airport's part at these stages?
So Mr. Thompson is heavily involved in this process as well. So he's coordinating all of these activities, both with the third parties, but also coordinating it with the developers themselves.
Okay, thank you. Now, you mentioned the concept of ongoing cost and risks earlier. What are the costs and risks for the airport?
Yeah, well, there's quite a few things to consider here, and I'll probably start by taking us to something that's been referred to on a few occasions so far, and that's electronic conspicuity, which has been referred to as EC. Now, I know Ms. Mackenzie firmly believes that the CAA is likely to mandate that technology, you know, in a few years' time, and that may well happen. And if that does happen, given the environment that the airport is in, with wind farms in our environment, we will have to expand what we would normally have to do in order to implement that technology. So I'm talking about the airport having to do things over and above what it would normally have to do to implement that technology. And I can't go in, you know, I'm not going to give you a technical explanation for that. I'll leave that to Mr. Fido to cover when we hear from him shortly. But essentially, we need to do that because the turbines have some residual issues on the SSR. So we'll need to invest in additional CapEx, and we'll need to, you know, be burdened with additional OpEx that will endure for the lifetime of those wind farms. And that will come as a direct result of the wind farms that are in our environment. Now, even if EC is mandated, I think there's been some discussion that if that were to happen, the PSR would no longer be required. And, you know, the airport is very, very clear that we do not foresee, you know, in the near future, or in actually longer than the near future, actually for the foreseeable future, you know, an airport, a Prestwick airport without a PSR. You know, we believe that will endure for a long time, that need will endure. And that means that we are going to constantly have to find solutions that can mitigate wind farms, you know, and that requires further investment, you know. Now, we've been advised by our experts that we expect the life cycle of the system to be somewhere between 10 to 15 years. So it's absolutely conceivable that should Clauchrie proceed, that we could be looking to replace our surveillance system 3 times within the life cycle of that wind farm development. Now, Terma is the only approved in the UK system at the moment. You know, if we're looking 10 years down the line, 20 years down the line, 30 years down the line, we have to ask ourselves some big questions here. You know, will Terma still be supported? We don't know. You know, what technology will be available that will allow us to mitigate wind farms? We don't know. What will the cost of those solutions be? We don't know. What compromises will we have to make in standard ATC for now? All of these things bring risk, and
sorry, Ms. Kilpatrick, we lost the connection with you there, so I need to ask you to rewind about 30 seconds.
What did I say last?
You were saying that there's no guarantees regarding future technology, I believe.
All right, okay, so yes, I was just making the point that you know, if we're looking 10, 20, 30 years into the future, you know, do we know that Terma will still be supported? No. Do we, you know, do we know what other technologies will be available? No. Do we know what the cost of that technology will be? No. Do we know what the, you know, the compromises that we will need to make in terms of the standard air traffic functionality will be? We don't. And all of those things come with risk and cost. Now, the other thing that I think's worth mentioning is that of tracks and track capacity, and I think Miss Mackenzie referred to that in her evidence, and Mr. Fido will come on to talk about tracks and plots when we hear from him shortly. But essentially, and this is real layman's terms, that the radar has a limited capacity. It's almost a bit like if you think of your laptop and it has a certain amount of processing capacity. Well, that's like the radar. And that capacity is used by various things. It's consumed by aircraft, it's consumed by the weather, the sea, birds, and it's also consumed by wind farms. Now, when a wind farm is built, there is an imposed requirement on the radar to provide that capacity. We have no choice. It's entered the environment and it's now sucked up and used a certain part of the capacity that is available. And that capacity is gone forever. It's gone for as long as the wind farm's there. You know, if you think about the laptop analogy again, this is something that's going onto your hard drive. This is not something that's on a data stick that you can take out and remove. You know, that's on your hard drive and it's on your hard drive forever. It's taken that capacity away. Now, you know, that capacity will need to continually be replaced. So each time we have to replace the radar, we talked about these continuing cycles, we'll need to replace that capacity because we have to provide for that wind farm. So, you know, it's a significant consideration for us, particularly given, as Miss Mackenzie, you know, has pointed out, this surveillance system is an essential part of our infrastructure. It supports our core business, which is aviation. You know, it allows us to provide safe air traffic services. And if part of that capacity of the radar has to provide for wind farms, it's not available to provide for our core business, so aircraft movements. So, you know, over time, what we will see as more wind farm developments occur, you know, and as there is growth in aviation movements, the airport is going to need to invest in additional capacity to accommodate growth in its own core business, i.e. that of aviation movements. Now, you know, that's probably going to be sooner rather than later when we consider, you know, the new era of aviation is not far away. When we think about drone technology, UAVs, we know it will happen, and we know that there will be, you know, a significant amount of aircraft, you know, of aviation movements associated with those. But that will, you know, require the airport to invest in increased capacity because the capacity we have is somewhat being used by wind farms. Now, the last point I just want to touch on is that of clutter, and I think we've talked a lot about clutter and the impacts that turbines have on radar display screens. But I think we, you know, need to be clear on this point that the impact of wind farms on our operations does not begin and end with clutter. You know, it has a, you know, that is a, you know, a significant impact, but it is not the only impact, and there are other degradations to the system that need to be considered. And again, you know, Mr. Fido will come on to talk about these in more technical detail, but we are absolutely certain that at some point those degradations to the system will need to be considered and they will need to be addressed. And in addressing those, the airport will incur incremental or additional cost, both probably in the form of CapEx and OpEx for the duration of the wind farm. And just to be absolutely clear, you know, these degradations will come as a direct result of having wind farms in our environment. Now, That's by no means an exhaustive list. That's just to give you an idea. As we're about to commission the system, we've already got a whole host of risks that we can see, real risks with high likelihood and probability of happening, hitting us in the medium term. And what I should also just point out here is that I've not talked about resource here in any of these things, but all of the things that I've just mentioned will require, you know, a significant amount of resource from the airport to deliver. We've touched on Mr. Thompson and the fact that he spent half of his work life over the past 4 years commissioning the Timor radar. You know, these are significant projects that, you know, we have to evidence safety cases for. So, you know, as well as CapEx and third-party OpEx, for example, we've also got to think about the people cost here.
Thank you. Now, you mentioned CapEx and OpEx there a few times. Could you maybe just clarify for us what you mean by CapEx and OpEx?
Yeah,
please?
so CapEx is capital expenditure. So think of the Timor radar, for example, as capital expenditure buying a piece of equipment. OpEx is operational expenditure. So, you know, that could include things like resource, it's your ongoing expenditure.
Okay, thank you. Now, Ms. Kilpatrick, I'd like to cover the use of a word which appears in the airport's inquiry statement and indeed on the safeguarding assessment process.
Yeah.
And that word is maintenance.
Mm-hmm.
It appears in paragraph 26 of the airport's inquiry statement, and I'll just read what's said there for speed. It talks about required mitigation, ongoing, recurring assessment, maintenance and adjustment of the wind farm radar mitigation solution. And indeed, looking back at the safeguarding assessment process, step 16 on that refers to ongoing maintenance of wind farm radar mitigation system through the life of the wind farm. What does the airport mean when it uses the word maintenance?
Well, it probably doesn't mean what most people would expect it to mean. It doesn't mean maintenance in the sense that somebody turns up and presses buttons and makes sure everything works. It's, you know, it's maintenance in the much bigger sense. It's maintaining our operations to stay safe. It's maintaining our safety assurance process, and it's maintaining the operating environment.
All right, thank you. Now, on the topic of wind farm mitigation agreements, what style of agreements has the airport used in the past when it comes to entering into this type of agreement?
Well, we've got perhaps 3 iterations of the agreement. The first 2 agreements were based on lump sum payments that were due at the start of the project, and the current arrangement is an annual payment that's due for the lifetime.
We seem to have lost Ms. Kilpatrick. Have you lost everyone? This will come on. We'll just wait a few minutes for Ms. Kilpatrick to come back.
Sir, I'm advised that we're trying to restart the connection, so hopefully it won't be much longer.
Very well, we'll just have to wait.
Sorry, sir, I'm told there's a problem with it connecting. We'll have to change the laptop. If we could just have 5 minutes to do that, so that might be better than having people hang around waiting for that. I apologise for it.
All right then. Well, let's stop there and reconvene in 5 minutes then.
Thank you, sir.
That looks like we're back up and running.
I can't hear you.
Oh, sorry, we've got a problem.
Can't hear.
You can't hear.
Yes, sir, we'll just let Ms. Coonan goes back to try to help with that problem.
Oh, sorry.
I apologise for that.
We've just had a laptop switch over. I promise I didn't touch the other laptop, but we've just had to change laptops. I've got the speaker on now.
Can you hear me now?
Yes, can hear you now.
Good. Then we'll get back to it. I think we last heard from you about describing the first generation of agreements having lump sum payments and then moving on to an annual payment on a per kilowatt basis.
Yeah, so just to clarify that, all agreements have been based on per kilowatt charges. The early agreements were based on lump sum payments at the start of the project, and the current one's megawatt based but is annual.
Okay, and thank you. And why has the airport decided to move to a new style of agreement?
Well, we understood that the situation had evolved over the past 5 years. We'd made an initial investment in a solution a system that has the potential to mitigate wind farms, and we're also very aware that the cost and risk burden that goes hand in hand with mitigating wind farms is ongoing, and it endures for the lifetime of the wind farm. And for both of those reasons, we deemed it more appropriate to move to an annual payment.
Okay, thank you. And you talked earlier about your ongoing engagement with other developers. Have they seen the new style of agreement?
Yes, we shared the new style of agreement with quite a few developers. It was probably approved by our board about 12 months ago. So it's been shared with a number of developers, and we have had several developers sign up to that new agreement.
Okay, and for those who have not yet signed up, what's their reaction been to the proposed method of charging?
Well, I mean, I think people view it quite favourably, and it's important to note that there were, that isn't the only change that we made in the agreement. There are other changes in this agreement that we believe are more favourable for the developer than the original two agreements, and generally the response that we've had from developers has reflected that.
Thank you. And from your experience of being in this sector now, where you're no doubt speaking to other airport operators and understanding what's happening in the renewables sector generally, to what extent is it commonplace to find arrangements put in place where the charge is per megawatt per annum?
Yeah, well, I don't know the quantum of charges that other airports or ANSPs levy, but I am aware that a per megawatt measure is very, very common.
Okay, thank you. Now, we've heard some evidence so far on non-disclosure agreements. What's the purpose of a non-disclosure agreement?
Well, it's a mutual agreement. It's there for both parties' benefit when they are talking about commercially sensitive information, and it protects both parties, both at the time and in the future. When I'm talking to developers about wind farm mitigation agreements, I'm privy to information about development, and the agreement, binds that confidentiality. I couldn't speak to another developer or another airport about the developer's interests, and it's perfectly normal part of the business process.
Yes, well, I was going to ask you that. How commonplace are these types of agreements?
Yeah, well, they're very, very commonplace, and certainly within the airport, all of our commercial arrangements are bound by confidentiality. And that's not just wind farms, all of our commercial arrangements. So it's not something that we, some special measure that we have for discussions with wind farm developers. And, you know, it goes both ways. We're on the receiving end of NDAs from third parties as well, and that's quite commonplace. I received an NDA probably 2 or 3 weeks ago from a potential supplier who was unable to talk to me about the commercial terms of supply until I'd signed an NDA. So, like I say, very, very normal.
Okay, now you may remember that in her cross-examination, Miss Mackenzie said that I do not believe a government-owned airport should be hiding behind a non-disclosure agreement. What would you say in response to that evidence?
Well, firstly, I think it's very important to say that the airport is a commercial organisation and it's operated at arm's length from Scottish Government. You know, and this isn't about hiding anything. As I've said, this is, you know, a perfectly normal procedure in business, you know, when discussing commercial arrangements. And, you know, I believe the applicant themselves has confidentiality arrangements for its Kincardine radar agreement. So, like I say, it's perfectly normal.
And you may remember that in her evidence, Miss Mackenzie said that the applicant was presented with a one-way non-disclosure agreement. What's your position on that?
Well, it's commonplace for NDAs and the contents of NDAs to be negotiated just like commercial agreements. In fact, I'd say, in my experience, it would, you know, it'd be very, very rare for the receiving party of an NDA not to mark up changes or, you know, request amendments to the details. And, you know, to be clear, right from the offset, when we first shared the NDA with the applicant, and that's probably towards the end of November last year, we invited comments and feedbacks. We shared the NDA and we, you know, with their legal team, and we asked them to provide us with feedback at that point. Now, between then and probably towards the end of February of this year, we went back on probably 6 or 7 occasions to ask the applicant to provide feedback on the NDA. Now, we never received a markup on that, and we did, you know, we did try, but clearly, you know, the applicant, I think, well, it's evident, wasn't particularly interested in signing that and seeing the agreement.
Thank you. Now, in the absence of a non-disclosure agreement, how much information did Miss Mackenzie receive about the style of agreement which was being proposed?
Well, we shared it was a per annum per megawatt charge. We shared that the megawatt rates were banded, and we also shared that there was a shutdown protocol.
And when would Miss Mackenzie have received that information?
We had a conversation after the pre-examination meeting. I think it was the 24th of February.
And that was the point at which the information was shared?
Yeah.
And you'll recall that when Miss Mackenzie gave evidence, she cited various calculations which she had carried out based on megawatt charges of a band 0 to 50 at 3,000 per megawatt, 50 to 200 at 2,000 per megawatt, and over 200 megawatts at £1,000. And she said that having applied those figures to what she believed the arrangement would be, that produced an annual contribution by the applicant of £552,000 per annum for the whole of their portfolio. And that would mean that the applicant would pay £16.5 million over 30 years for mitigation. What would you say in response to those calculations?
Well, I think Miss Mackenzie admitted herself that those figures that she quoted were entirely made up and not grounded in any fact. As we've said, we haven't shared the details of the agreement with the applicant. And whilst it's not really appropriate for me to discuss commercially sensitive matters in this public forum, what I will say is that those figures bear absolutely no resemblance to the facts.
Okay, thank you. Now, I'd like to take you to paragraph 23 of your recognition. And if you have that, just let me know when you have it.
Yes, I have it.
Yeah, thank you. And it's the second sentence in that paragraph which says, given that SPR and the airport are both commercial organisations, the amount to be charged should therefore be left to negotiation, as would be expected in any commercial environment. Could I ask you to expand upon what you meant when you said that in your recognition?
Well, I think it's really important that we do remember that, you know, both SPR and the airport are commercial organisations, and SPR's activities in developing this wind farm has an impact on the airport, and that impact transfers cost and risk to the airport that it would not ordinarily have to bear. So it is, you know, right and proper and very, very normal that those two organisations would get together and have a discussion about that, and the airport would share its thoughts on the cost and risk exposure. You know, and a big part of that we need to bear in mind as well is, you know, the amount of resource that will be required over the lifetime of the wind farm to, you know, to work on matters that are solely wind farm related, and I've touched on some of those risks earlier on. But we would have a discussion about that, and you know, it's again a perfectly normal and reasonable part of a, you know, commercial negotiation.
You referred to resource there. Just to be clear about this, when you referred to resource, what were you referring to?
Well, I'm talking about the time and effort, the people time and effort that the airport has to invest in projects that are solely, or things that are solely for the benefit of wind farm mitigation, things that we would not ordinarily have to do as a business if we weren't mitigating wind farms. And that translates into OPEX.
Sorry, OPEX,
operating expenditure. Sorry.
It's like, you know, it's just there was a slight delay on the relay there. That's fine, thanks. Now, in paragraph 17 of Miss Mackenzie's recognition, she says, and I'll just read the sentence: GPA has to date recovered over 8 million for wind farm mitigation. See paragraph 103 of my inquiry report and the table thereunder. A thermoscanter 4002 costs 3.5 million. It's difficult to see what further recovery GPA requires. Now, just stopping at that, what would you say in response to that statement?
Well, I'd say it's completely misleading. And I also think it just highlights the, you know, the lack of awareness of the, you know, the true costs of the system. I mean, Terma's reference there. I think we need to just remember that Terma is actually only part of the system. It's a very, very important part of the system, but it is not the only part of the system. You know, there is additional cost over and above Terma. And we're very, very aware that in the near future, we're going to have to make additional investment in the Terma because we need to increase its range. The current range, you know, isn't as great as the range that we have on the existing radar. The technology wasn't available at the time that we acquired the radar 4 years ago, and it is now, and we'll need to make an additional investment in order to regain the range that we have with the existing system. So I would say that figure that's been quoted doesn't represent the total capex that's been invested, and it certainly doesn't reflect the investment in time that the airport has, you know, has dedicated to this over the past 4 years. And certainly over the past 4 years, you know, as we've already said, Mr. Thompson has spent probably half of his time dedicated to this project, and that time comes with a value. Now, the other thing is, you know, completely disregarded in that statement is, you know, there's a lack of recognition that the airport, as a result of wind farm mitigation, is exposed to incremental or additional costs and risks. And these are things that will happen over the next 20 years, you know, and we will have to bear the burden of those, because the payments that have been received to date for those 8 wind farms are lump sum payments. There, you know, there are no additional payments for those wind farms. It's paid up front. They aren't the new agreement. So in summary, I would say it doesn't represent capex. It doesn't represent the, you know, the investment in time and people that does have a real value. Our employees, you know, are there to add value to our business. You know, they have to contribute and add value in some way, and we've dedicated huge resource to this project, and that has a value, and will also be, you know, be exposed to cost and risk, as I've already said, for the next 20 years, and that needs to be covered, you know, by the outcome.
Okay, thank you. Now, again, when Ms Mackenzie was giving evidence in cross-examination, she said that Prestwick is using its safeguarding function to extort and demand payment. What would you say in response to that?
Well, I'd say that's quite an emotive statement, and I don't really think it's in the spirit of what we're trying to achieve here. You know, we have to remember that wind farms are imposed on the airport. We don't get an input into where they're sited. We don't get to decide how tall they are, how big the blades are. You know, this is something that is, you know, put in the environment, and we need to try and deal with. And where, you know, and we're absolutely unequivocal that these things do have an impact on our operations. And the impact on our operations means that we then need to bear long-term additional cost and risk. And that comes as a direct result of the developer's activities. So, you know, it's perfectly logical and reasonable to say that the developer should pay for that. You know, and if the developer doesn't pay for that, the airport is effectively subsidising their activities.
Ms Mackenzie also accused the airport of abusing its dominant market position in the provision of mitigation. How would you respond to that evidence?
Well, I would repeat what I've just said, really. You know, the airport understands its importance of its role in enabling renewable energy. But when that has an impact on our business, and that impact translates to cost and risk that we wouldn't ordinarily be, you know, exposed to, I don't think it's reasonable to expect that the airport should absorb those costs.
When giving evidence under cross-examination, Ms Mackenzie suggested that the airport may have been motivated to change its form of charging so that the mitigation payment became hidden as non-recurring revenue, and so there would be no transparency. What would you say in response to that?
Well, I think we've already covered that. We've already talked about the rationale for changing the agreements. You know, the environment had changed, it had evolved, we'd acquired a new system that had the potential to mitigate. You know, we're alive to the fact that the cost and the risk, you know, happens throughout the lifetime of the wind farm, and therefore, you know, we changed the payment structure to be annual rather than lump sum and upfront. You know, it's perfectly normal, keep saying perfectly normal that, you know, certain revenue lines, you know, are not broken out in accounts. That's the same for, you know, for all places. It's the same way that, you know, as far as I'm aware, SPR don't break out the revenue that they generate from the Kincardine radar. It's, you know, it's not unusual.
Okay, you will recall that earlier we talked about the high-level principles of the new style of agreement, which were discussed with Ms Mackenzie, and you did say that there was reference to a shutdown protocol. When Ms Mackenzie was giving her evidence, she suggested that the airport demands the right to shut down turbines willy-nilly. What discussions actually took place with Ms Mackenzie about the shutdown protocol?
Well, we didn't have any discussions about the shutdown protocol. We had a phone call and talked about some of the basic principles of the agreement, and you know, informed Miss Mackenzie that there was a shutdown protocol, but we didn't, you know, have a discussion. That would come when we share the agreement in full, and, you know, and have a full and open conversation about all the terms, including that. And, you know, if we'd had that opportunity, then we would have explained, you know, why we felt it necessary to have that protocol in place, and, you know, under what circumstances we would invoke that, and, you know, the reality that we would not expect to ever have to do that, but it's something that we feel we need to have in order to meet our safety obligations. We'd also have shared that there are limitations on the period of time that we could enforce the shutdown notice for, and if we were to ever do that, that we would recognise that the developer would bear financial consequences from that decision, and as such the airport would be contractually bound to financially compensate the developer.
And so then, having said all of that, what of this description willy-nilly?
Well, I wouldn't agree that we take a willy-nilly attitude to shutdown protocols.
Okay, moving on then, Ms. Kilpatrick, to what has been described in the earlier evidence as the dichotomy of views between the airport sector and the renewables sector about accepting turbines into the baseline environment. What's your understanding of that dichotomy?
Well, if the developers' views are reflective of that sector, and based on the discussions I've had with other developers, I'm not entirely convinced that is the case. But if the applicants' views are reflective, then I think the dichotomy is quite clear. I think the developers' view is that once an investment's been made in a technology that has the potential to mitigate, that it's business as usual for the airport. There's no ongoing cost and there's no ongoing risk to the airport, and as a result, no charges should be levied. I think in reality, airports and ANSPs are acutely aware that there is ongoing additional cost and significant risk that comes part and parcel of mitigating wind farms, and we seek payment for that commitment.
Okay, and being part of the aviation sector, if you can put it that way, you operate an airport and you provide radar services. You'll no doubt discuss approaches with other airport operators and other radar operators. As a result of those discussions, what's your understanding of their views on this topic?
Well, I think they share the view that I've just expressed there. Mitigating wind farms comes with a cost and a risk to airports and ANSPs, and wind farm mitigation agreements are an essential part of the solution that allows airports and developers to coexist, to work together. It gives developers certainty that they can carry out their activities in the long term, and it gives airports the certainty that they are not exposed to additional cost and significant risk.
Okay, thank you. Now, taken broadly, I think there's a suggestion in the evidence which has been presented by the applicant to the inquiry that the airport is in a state of decline. Now, you're the commercial director for the airport. What's your view of the position of the airport at this point in time?
I don't share that view. The airport's delivered significant growth over the last 3 years, driving revenue, managing costs, improving profitability. So, I certainly don't share that view, and I don't think there's any evidence to support that either.
And looking forward, what opportunities do you see for the airport?
Well, we're working on quite a few new business development opportunities at the moment, but we have quite ambitious plans to grow both some of our existing revenue lines and pursue some new lines. We've touched on drones and UAVs. We certainly see that part of the near future for us, where we're working on spaceport developments at the moment. So there are lots of opportunities over and above our existing business, but we still see growth in some of our core markets as well.
So when Ms. Mackenzie said in her cross-examination, if the airport's business case cannot sustain its investment in its core aviation services and the infrastructure it requires, then should it be in that business? And the last part of that was a question, should it be in that business? What's your response to that question?
Well, I'm not sure who said that the airport can't afford to support its own and invest in its own infrastructure. It's certainly not a view that I share, and it's not a view that the executive at the airport or the board at the airport would share either.
Okay, thank you very much. Ms. Kilpatrick, I've got no further questions.
Thank you, Mr. Brown. Now, I'm aware of the time and of Ms. Kilpatrick's availability. There's some discussion that Ms. Kilpatrick wouldn't be available later in the week. So can you provide any update on that and whether we need to finish with Ms. Kilpatrick today or whether we can go on tomorrow?
Ms. Kilpatrick is available tomorrow morning, sir, to take up cross-examination at that point.
Mr. MacLeod, how much time do you think you'll need with Ms. Kilpatrick?
Realistically, I won't finish today. I mean, I would expect a couple of hours, certainly finished by lunchtime tomorrow at the latest, although as with all things, it depends on the answers that I get and whether I need to ask further questions.
And Mr. Brown, and Mr. MacLeod as well, the radar witnesses, they are available on Thursday and Friday, are they?
Yes, they are, sir, as I understand it.
In that case, how do you react to the suggestion that we finish here for the day and we pick up on cross-examination in the morning?
I think that would be sensible, sir, given that we've been here since 9:30.
I'm happy enough with that, sir. Yeah, I'm happy enough with that. And I think if it assists, Mr. Brown and I had a conversation earlier in the week, and I think that the terma letter probably means that both of our witnesses will take less time than they would have otherwise taken. That I think was our initial reaction to the terma letter. Yes, I think we're both comfortable that we'll get through 3 witnesses before close of play on Friday.
Yes, and that's obviously my main concern, is that I think it's essential that we finish by close Friday.
Yes, I think that's achievable.
If you're both confident of that, then we'll stop there for today, and we'll come back at I think we can come back at 10 o'clock tomorrow.
Thank you, sir.
Thank you.
Thanks, sir.